The affidavit nuclear filed yesterday, my lord, that may point.
Yeah, please, Your Lordship.
Item number 22, my lord. Item number 22, my lord. In this case, my lord, there is my lord, clerical mistake, my lord. So far in my lord, regarding my lord, authorization, my lord, in paragraph 2, my lord. It was my lord, there is blank, my lord, already. It is blank, my lord. So clerical defect, my lord, I am be allowed to correct, my lord.
Item 62, we are filing an additional affidavit that may kindly be called.
My lord, item number 44 has become infractious, my lord. Order has been
Number?
complied with. 44, my lord. Order has been complied with, my lord.
Why is it infractious?
My lord, the petitioner has got the relief, my lord.
Mr.
W. Rahman.
Submits that the judgment and order dated so-and-so, passed in so-and-so, have been duly complied with. He therefore submits that the petitioner therefore would not like to further pursue with the instant proceedings. Taking into account that the judgment and order dated so-and-so, passed in so-and-so, have been duly complied with, comma, the contempt proceeding stands dropped.
My lord, in item 39, my lord, we have filed a reply affidavit, my lord. Yes, sir. That's not.
Item number 14, my lord, we have filed affidavit reply yesterday. I am going to bring on record, my lord. Much obliged. Sorry, my lord. See.
Yes, what is the case about? What are you challenging?
My lord, impugned order at page 93, my lord.
Huh?
Page 93, my lord.
Page?
93, my lord. Actually, petition. My implement petition was rejected by the Honorable Revenue Board, my lord.
Yes.
Yes. My lord, I filed the application before the Honorable Revenue Board, my lord, at page 97, my lord.
Page?
Page 97.
Yes.
Ma'am.
You have filed your appeal. Let's see your appeal first.
Now, appeal filed by the respondent, my lord.
Who are you?
I am the, my lord, they filed the appeal, my lord, for correction of a patta, my lord. In which patta, my lord,
Where's the appeal?
appeal copy is not.
Okay, against which order they have filed the appeal?
Appeal file, my lord, order dated, my lord, page 86, my lord,
Page?
86.
What is your name?
My name is, my lord, Gauhati Roy and Amir Ali, my lord. My lord, in this order, my lord, that
Who has filed the appeal?
appeal file,
Ray.
Minajiban Burwa, my lord.
And who is Monbola Ray?
Monbhola, he is a tenant, my lord. He is a tenant, my lord. The tenancy has been created by an order by an order of the Assistant Settlement Officer.
So you are not related to this Monbola Ray.
No, but I am one of the tenant by which the tenancy of the Monbola Roy has been created, my lord. This order, my lord, kindly see page 86 relevant portion, my lord. Peruse records gone through the status report submitted by the SO organization. It is revealed that the SO has submitted detailed position of the present record and file and field position. It is found that the land in question under aforesaid Dag and Patta is under possession of the opposite party since long back. The ASO Agamoni passed an order dated 2/5/2008 in miss case number 109/2007 after due permission from the office of the undersigned by letter date so for creation of tenant in the name of the present opposite party. And in this regard, the petitioner never filed any objection or appeal against the said order, my lord. Against this order, my lord, page 22, the order dated, my lord.
So this miscase is dismissed. Miscase filed by some Mrinal, Jibon Borua and two others. So this application was filed for correction of the number.
Patta. Name of the tenant cancelling the tenancy, my lord.
Where is this petition filed by Archana Borua?
This petition.
Yeah. Okay. With reference to that, I'd like to inform you that I'm the absolute owner of a plot of land as referred to in the settlement and aforesaid, but I have issued it after going to the name of Monbola here been figured in the variety column. The Monbola was never been illegally entered. Who have filed an object since now. Nothing. So here Archana Borua was aggrieved by the insertion of Monbola Ray's name. Okay. Now this led to the order passing of order of 16/9/2017. Isn't it? This is in respect to correction in KP Patta number 622 in respect to Dag number 25. Okay. Now, this application was rejected.
Yes.
Isn't it?
But
Now an appeal thereagainst was filed by the heirs of Archana Borua, which is appeal 70 RA Dibrugarh 2017.
my lord, the tenancy has been created.
Now, wait. Then you filed an application.
For implement in the appeal, my lord. Because if my lord, tenancy is cancelled, my lord, our right will be violated because the tenancy has been created by a common order. In miscase number, my lord, this in miscase number 109/2007.
Your tenancy has been created in which Dag?
Different draft.
Then how does it have any relevance?
Because my lord, kindly see the page 22, my lord. Page 22.
Yes.
By this order, my lord, tenancy has been created against the three tenants. Tenant, my lord. Because the earlier tenancy has been cancelled in 1988.
But the application which was filed by Archana Borua was in respect to a Patta number
22.
KP Patta number 622 of dark number 25.
Yes, that number.
Your tenancy has been created where? What is your name?
My lord, my name is my lord Gulapi Roy and Amir Ali, my lord. May I read?
And Amir Ali.
Amir Ali.
Yours is created in, therefore, the so and so, so and so, so and so, and covered by the name of Amir Ali of 1602.
Yes, my lord. Same patta, my lord.
What same patta?
622 a patta number.
What 622?
Yes, my lord.
Where?
My lord, may I read, my lord?
Yes.
According to the report, land mandal of Drapsita record, it is seen that the land measuring so and so, so and so, so and so of patta number 49 and Khiras Medi patta number 622 of village Kaldapara in total at 13 biga 3 kata 2 lessa is recorded in the name of Archana Barua, wife of late Piti Jiban Bure as patta. It is seen that land record that is covered by so and so, so and so, so and so land measuring so and so, so and so. One namely Amir Ali, late Hengashek, and in land measuring 2 biga was covered by the so and so, and one namely Golapi Rai, daughter of late Khoria Rai, has been enjoying the right of occupancy by cultivating the and paying rent to the Jotedar since 25 years. The Monbhola Roy names and Amir Ali's name and Golapi Roy's name has been inserted in the record of rights as tenant, my lord, by this order, my lord. And this land, my lord, actually is a parcel of a compact portion of land on 68 biga, my lord. The original Khotiandar of this land, my lord, was Sharat Chandra Borua, my lord. This land was acquired under the Acquisition of Zamindaris Act, my lord. And in 1982, my lord, the tenancy was created. Rayati Khotian were issued against the possessor of that land. But in 1985, my lord, those were cancelled. Though the possessor of the land, my lord, Rayat, did not know about the cancellation, my lord. Only they come to know, my lord, in 2007 when the land was acquired by the railway department, my lord. And in that, my lord, process of the acquisition process, that this tenancy was again created, my lord, against the possessor, my lord. But if, my lord, Monbhola Roy's names, by this order, my lord, the name of the Monbhola Roy and Amir Ali and Golapi Roy has been inducted in the record of rights as a tenant, my lord. And this order has not been challenged before any other authority, my lord, by the respondent, private respondent.
It's the council. Page 85 is the application. 85 only says about Monbola Ray.
Only Monbhola Roy.
It is not in reference to you. This is not in reference to you.
No.
Then why you are worried?
Because, my lord, if my
Here it is categorically saying that Monbola Ray is not my tenant. And as such, kindly don't insert his name. That's all.
because, my lord, if Monbhola Roy's tenancy goes, then the revenue board has to cancel this order.
Why?
Because tenancy has been created by this order, my lord.
They are not asking for cancellation of that order.
Yes, my
They
lord.
only say no.
But
You see, it is seen. Therefore, on the basis of occupation and so is granted in the record in the name of Monbola Roy, late so in respect in the land of 4 bigas so covered by so 2 bigas covered by so the name of Amir Ali in the land of so measuring so has been done. So
yes.
why you are putting yourself in when they are not challenging it? Why you are putting your foot into this thing unless you want to delay the disposal of the appeal?
Because apart from that, my lord, my tenancy has been, my lord, there is another appeal, my lord, in 101, my lord. That order, which I have mentioned, my lord, there is a tenancy dispute against the Rayati Khotian issued in 1982. That tenancy has been upheld by the Honorable Revenue Board, my lord. Same land, my lord.
Very good. Be happy. We are only on the question as to whether the learned Board of Revenue was justified in rejecting your impleadment application.
In respect of only that number so and so, my lord.
Right?
But if order is gone, my lord, then
Order is not put to challenge.
yes, my challenge, my lord.
No. Where is the challenge to that order?
My lord, if your lordship, by deleting the name of my lord, the application, my lord. Page 85, my lord.
Yes.
Said
Order is
Monbala
not
was
challenged.
never,
Order only, this application only refers to Monbolare. We dismiss your heard, Mr. So-and-so, the learned counsel appearing on
but
behalf of.
my lord, only of the.
No, remaining in for division bench.
My lord, 101, may I submit this order?
No. On behalf of the petitioners. Miss N. Bordley, who appears, M. Bormon appears for respondent number 1, 3, 4, 5, 6. Miss N. Bordley appears on behalf of the respondent number 2. Mr. So-and-so appears for 7 and 8.
7, 8, and 9.
9.
I'm personal appearance for 7. I am the party to this proceedings of 7 personal appearance, 8 and 9. All 7, 8, and 9 represent.
7, 8, and 9.
Yes.
You cannot appear.
My lord,
Appears the Mr. M.J. Borua appears for a respondent number 7. However, none appears for 8 and 9. The petitioner herein have assailed the order dated 18/3/2019, whereby the application filed by the petitioners seeking impleadment in the revenue appeal being 70 RA bracket DBR oblique 17 before the learned Assam Board of Revenue was rejected. The brief facts which leads to the filing of the instant application are that in pursuance to an order passed by the Assistant Settlement Officer Agomoni Circle dated 2/5/2008, names of various persons were mentioned, were recorded as tenants under the predecessor in interest of the respondent number 7, 8, and 9. It included the name of one Monbola Ray. What is the spelling? Monbhola, Monbola Ray. In respect to DAG number 1/1595 old /25 new of land admeasuring 4 biga 1 katha 7 lechas, and also the names of the petitioners against various other DAG numbers forming a part of patta number. What is the patta number? 49.
622.
Patta number 622 of village Kaldoba, part 1. Pusto. The predecessor in interest of the respondent number 7, 8, and 9 filed an application on 3/12/2015 before the settlement officer. stating inter alia that the insertion of the name of the said Monbhola Ray as in the riot column against Dag number 25 for an area of 4 bighas, 1 katha, 7 lechas was incorrect, was illegal, taking into account that the said Monbhola Ray was never a tenant under the predecessor in interest of the respondent number 7, 8, and 9. This court finds it very pertinent to take note of the said application, as it has a bearing on the adjudication of the present dispute. The contents of the said application is reproduced herein under Annexure Roman 18, page 85. The settlement officer, by an order dated 16/9/2017, rejected the said application filed by the predecessor in interest of the respondent number 7, 8, and 9, holding inter alia that from the report so submitted by the ASO Agomani Revenue Circle, it was found that the land in question in Dag number 25 of Patta number 622, Rayati Khotian number 420 of village Kaldoba, part 1 under Agomani Revenue Circle was under the possession of the said Monbola Ray since long back. It was also mentioned that the ASO Agomani had passed the order dated 2/5/2008 in miscase number 109/2007 after due permission from the office of the settlement officer for creation of tenant in the name of the said Monbola Ray, and the predecessor in interest of the respondent number 7, 8, and 9 neither filed any objection nor filed an appeal against the said order. Being aggrieved, the respondent number 7, 8, and 9 filed an appeal before the Learned Board of Revenue, which was registered and numbered as appeal number 70 RA bracket DBR oblique bracket close oblique 2017. In the said application, the petitioners filed an application. In the said appeal, the petitioners filed an application seeking impleadment on the ground that if any order is passed, setting aside the order dated 16/9/2007, the petitioners would be affected. The said application seeking impleadment was rejected by the impugned order dated 18/9/2019 by the Learned Board of Assam Board of Revenue. It is under such circumstances the present writ petition was filed before this court. This court have duly taken note of the contents of the impugned order, whereby the Learned Assam Board of Revenue have rejected the application, taking into account that the Dag number in the cases of the petitioners were different from the Dag number in the case of Monbola Ray, which was the subject matter of the appeal filed before the Assam Board of Revenue. This court have not only taken into account the impugned order as well as the application so filed by the petitioners before the Learned Assam Board of Revenue, but have also taken into account the application which was filed by the predecessor in interest of the respondent number 7, 8, and 9, which have been quoted here in above. In the said application so filed, which led to the filing of the appeal before the learned Assam Board of Revenue, there is no mention as regards the petitioners being not tenants under the predecessor in interest of the respondent number 7, 8, and 9. The said application was directed only against one Monbola Ray and not against the petitioners. Under such circumstances, this court finds no merit in the instant application. Accordingly, the instant writ petition, writ petition stands dismissed. Cost with cost of 10,000 rupees.
My lord, this is the
The interim order so passed on 10/6/2019 stands vacated.
cost, my lord, 10,000.
Why? Unnecessarily filing and getting it stayed for last 7 years. You have no business out there in that application,
But there are so many cases.
and you have been asked to file an impleadment application. You didn't even file that. Why shouldn't they? Okay, 10,000 cost on him. What is your name? On you. And 10,000 to the petitioner and 10,000 to you.
Obliged,
Cost.
obliged.
Yes, Mr.
My
Bhatti.
lord, so far item number 7 is there. I am there, my.
Item number 7, you're
Yes.
withdrawing.
Not withdraw. Not withdraw, whether I am liable to pay the VAT or not, my, lord, in this particular case.
Item number 7.
7.
What is item number 6?
Item
6 is similar, my lord.
Okay, then which
Same.
matter you are starting?
7, my lord, it is my matter.
Whose matter is 6? Argue? Or you want him to lead the argument?
In 6, my lord, the ad valorem levi stay has not been vacated, my lord. Because in item 7, my lord, the stay is vacated.
Don't worry, we dismissed right now. Yes, what is your case?
Lord, it's regarding,
Excise duty. How did the matter come up? Yes, what is your case?
my lord, it's a demand on the levy and VAT. My lord, before 2000, my lord, 19, 16 rules, my lord, there is a joint committee constituted, and as per that,
I dispose of some matters.
Matters have, my lord, one matter was disposed, which became the precedent on whether excise duty on non-consumable stuff is required to be paid or not.
That also I disposed of. I disposed of one set of repetitions whereby the case was, you see, from 2020, you have these rules, or 2016, but it was given effect from 2020, I suppose. There was a committee set up. This committee which was set up, this committee categorically mentioned how it is to be done. That because what has happened is these wholesale warehouses at that point of time, they did not need to pay the VAT
Prepaid.
because it was a part of the bonded warehouse.
yes,
The bonded warehouse at that point of time was a part where it was shown that there was no requirement of payment. The payment will only be made at the first stage when they collect and the payment has to be made by the retailers at that point of time.
yes,
Now, with the amendment being brought into by the Excise Act, the effective thing is now it is the bondage warehouse which is there has to be a part of the manufacturing. And therefore, all the other bonded warehouse, which was not a part of it, had now become a wholesale warehouse. Petitioners are wholesale warehouse. Now the question is, at that point of time, there was a joint committee held, and the joint committee directed certain people, have made the assessment, looked into all these things, and there was a governor's letter or some notification to the effect how it is to be done. After that, they fixed out those things which are there. Now, as regards the cases where the goods were damaged or whatever may be damaged and all, then also the payment of the excise duty has to
Duty
be
has to
made.
be paid.
That is what I think this is Arun Dev Chaudhary had held in that judgment. So that is it.
That is-
Now, what does he want?
Now, my lord, the remaining part, whether VAT needs to be paid or not
Yeah, definitely.
for that unsold stock. But my lord, I have filed an affidavit in item 7, my lord, I have filed an affidavit where my lord, when that notification was issued, and so subsequently my
That is on sale.
on sale, my lord.
You see, if there is no sale, there is no VAT.
Exactly, my lord.
Now, here the question is, where is the tax department? The VAT has to be collected by
They,
the
my
tax.
lord, they made the submission that they don't need to file affidavit. They should have, my lord, but they said they, so
It is
we
their
have
VAT.
filed
It is, if it is a case of VAT, they have to pay. But as regards excise, you are more interested.
For VAT also, my lord, we have brought out the relevant statute, my lord.
Understood. But VAT, you are not to protect the VAT. You don't have any business to protect. You have only to see the excise.
We collect it together, but the
So
enforcement.
VAT not required. Now, nobody is supporting the VAT. It is not required. We only are concerned with the excise. Have they paid the excise?
In item 7, it is vacated. We have asked the department to proceed. In item 6, the stay is still continuing, my lord. So that
Okay.
may be vacated, my lord.
Okay, we vacate that. Excise they have to pay. And VAT you don't pay. They have not filed an affidavit. They are not contesting against it. So we don't pay that. No instruction business.
In
Don't pay.
our affidavit also, my lord, we have written why VAT needs to be imposed, because my
Why?
the taxable.
Why? Why are you going into this VAT business? You are concerned with excise. We know that all the departments have different, although because in government of Assam do not speak in one voice.
No, we want
No, no.
statutory implication.
Yeah. I made this.
Now tell me, at that point of time when they were having the goods with them, then it was free from excise because the excise they give a bond.
Yes.
That your excise is protected. I will pay you when the amount is when I get it from my retailers. So at the time of release from the retailer, from the bonded warehouse, they have to pay it to they get collected and then pay the excise. As regards the VAT also, it is free because it comes from the manufacturer and then comes to the bonded warehouse, or from the company, it comes to the bonded warehouse. And at that point of time, there was no tax. Now this bonded warehouse is no longer there. So those stocks which were retained by them, as regards the excise, they are liable to pay. But unless there is a sale, where is the VAT? There has to be a sale.
Yes, my sale
Where is the component of sale?
from the my lord, wholesaler to the my lord, retailer.
So unless there is a sale, where is the sale? So there has to be a sale.
Yes.
Have you found out that there is a sale?
In order to pay the my lord back.
Because the sale has to happen.
Sale,
VAT.
my lord, moment, my lord, they challan, they.
Manufacturer to warehouse.
Hmm.
According to warehouse.
VAT not prepared.
No,
Finance taxation department is not prepared. What do you say, Mr. Bhatti? Not prepared.
no,
So unless there is a sale, because you see, VAT, the point of charge,
yes,
as was amended, was at the time when it is being taken by the point of first sale.
first sale will be from the company to the, my lord,
No, company, it has happened.
yes,
So company, there was no sale at that point of the company has given it
the warehouse,
to the warehouse.
my lord.
Because the warehouse was in a system, they used to just keep it. There's no sale to them. They are not, they become a wholesale distributor later on. They became a wholesale distributor in the year 2016 or 20, whenever it is. So they had to pay the VAT. Then,
Yes.
what are the goods out there?
No, only for those part, that is there in my instruction, my lord, that, my lord, whatever was left out with them, my lord, moment their status has changed, then, my lord, they are liable to pay. That's why they are liable
So
to pay.
at that point of time,
The unsale part.
so when is the sale?
My lord, moment, my lord, it comes to, my lord, to the, this warehouse and all, my lord, then it goes to the retailers, my lord.
Understood. The moment you see earlier what was happening. Bonded warehouse used to keep it. There is no sale. This was they are not wholesalers or anything. Nothing at that point of time. What they were doing is, on behalf of the state,
My
the state sees that our excise is to be protected. So we have this bonded warehouse where you can go and keep it because it's an excise duty.
my lord.
So it has to be kept out there. And as such, it was not required to pay. Now, by way of the amendment made by the Excise Act, the new Excise Act, as well as the rules framed therein under, the bonded warehouse, now the definition is the bonded warehouse will become a part of the manufacturing. Means the company and the bonded warehouse has to be one and same.
Warehouse.
All others became a wholesale warehouse. Wholesale?
Warehouse.
Wholesale, they became a wholesale
Wholesale what?
warehouse.
Wholesale warehouse. So where is the sale? Which portion is the sale?
If I may point out,
Please.
when the amendment was brought, my lord, in 2016 to VAT, what happened, the sale from the manufacturer to the wholesale warehouse, my lord, that has to be borne by the wholesale warehouse, earlier known as bonded warehouse. So on that sale, my lord, this VAT was imposed. We have brought it out in the affidavit, my lord. And this amendment is not under challenge. That is another aspect. They were designated as dealers for the purpose of tax collection, wholesale warehouse.
Where is that?
In the affidavit, my lord.
Okay. Why you are helping the finance department?
Ultimately, it is public money.
No. They then consider you to be a part of it. Finance department doesn't consider you to be a part of it. Where is that?
In item 7, my lord,
That is what
we
I
have
am looking into.
filer affidavit starts at running page 47.
Huh?
Running page 47, the affidavit starts.
Ah.
Then, my lord, will see the annexure. Annexure A.
Annexure?
A. The Assam VAT Amendment Act 2016.
Yes.
There, my lord will see in the next page, page
A
53.
tax on the sale of goods specified in the fourth schedule. Fourth schedule is the first point of sale.
Yes.
Shall be levied and collected on the maximum retail price in respect of all such goods for the maximum retail price has been made as the base of the levy against such goods in the schedule. For that purpose, so and so. Then, which you are referring to,
Then, my lord will see 1B.
notwithstanding anything contained in this act. When was this amendment?
Amendment came into force on 26th of August 2016. Notwithstanding anything contained in this act, in case of potable liquor mentioned in the fourth schedule, every country spirit, if the first sale of the item is made by a manufacturer, bottler, or distillery, breweries, we are not concerned with 1B. Are we concerned with 1B? No.
Yes, because
No,
it's
not 1B. This is potable liquor. Potable liquor would not be them. Country spirit, we have to go into which one? Except country spirit.
except country spirit.
Notwithstanding anything in this act, in case of potable liquor mentioned in the fourth schedule, except country spirit, if the first sale of such item is made by a manufacturer, bottling unit, distillery, brewery, hereinafter referred to as the seller, located within the state, the wholesale warehouse licensee, or any other dealer who purchases such item from such seller, shall be liable to pay tax on the purchase of such items on the price consideration, including the excise duty. Such wholesale warehouse or any of the seller purchasing such items shall make prepayment of the tax payable under this act into the government account in a prescribed manner by a challan. Notwithstanding anything on in case of potable liquor mentioned in a except country spirit, if the first sale of such item is made by an importer wholesale warehouse inside the state, he shall be liable to pay tax on the sale of such items. Such importer wholesale licensee before importing a consignment of liquor at the state deposit an amount of the advance equivalent to the amount on the estimated sales so and so. Such amount shall be deposited into the government account in for the wholesale India will never be eligible to tax credit of the advance amount paid during the so So this section is not under challenge.
Not under challenge.
So therefore they become the first point of sale. So they will be liable to pay.
In the notification dated 29th of August 2016.
2000?
29th of August 2016, there is notification. It has been annexed in both the expedition of the proceedings taking up. Sanjay Sarkar to
Let us take number 7.
In
Item
7
7,
mile,
yes.
that notification is at
Sanjeev
page
Kumar
20,
Chauchoria.
22.
22.
Huh?
Page 22.
Yes. Now this I know. I've dealt with this matter a lot. They are withdrawn by this. This is just prior to coming into because it came into effect from 1A9, I suppose, na?
16.
So this was given that they should all look into all the wholesale lenders shall store and sell only such liquor on the excise duty and VAT has been paid. Okay. Now, so bad case, what do you have? No case. The sale is by deeming has already happened. By operation of law, you are now being brought within the ambit of the first point.
No, my lord. For this particular, may I take your lordship again to the amended Sales Tax Act 1C, 41C. That makes the position very clear, my lord.
Fantastic.
Once,
Yes.
may I read it?
Huh?
Notwithstanding anything contained in this act, in case of potable liquor mentioned in the fourth schedule, except country split. If the first sale of such item is made by an importer, wholesaler bearer license inside the state, he shall be liable to pay the tax of sale of such item. There must be the sale, my first of all.
Huh?
Until unless there is a sale, my lord, within the purview of this clause, I am not liable to pay the tax. Secondly, my lord, your lordship will see, such importer wholesaler shall be before importing a consignment. This word, importing. If I import any consignment after coming into force of the Excise Act 16, my lord, I am liable to pay the tax. But so far the first part is in relation to the sale, and it does not say that whatever the stock I had at the relevant time in my possession, my lord, and which were found unsellable or unconsumable, and upon that one I am payable, man. That is not there, man.
Unsellable, you get the benefit under rule 9.
Rule 9, my lord.
Get the benefit.
No, my lord, that benefit, because this particular provision does not say that I am liable to pay the tax on the stock.
So you mean to say this act, this amendment is made prospective. This amendment is made prospective.
Prospective,
And any sale which takes place, you are liable.
I am liable.
But in respect to goods which were already there
Yes,
earlier, where you have not purchased it, there is no sale
sale.
at that point of time.
Yes,
At that point of time, those, as there was no sale, so therefore the question of you paying tax out there
yes,
does not happen.
that is the thing.
Fair point. Chalo. What do you say? Jane, it appears to be a very fair point. Because at that point of time, there was no sale.
Prior to my lord, amendment.
Prior to the act coming into force, act came into on 1/9/2016. So all these goods which were there was no sale. Because the law did not permit a sale. It was just stacked. From 1/9/2017, 16, they become to the status of a warehouse. At that point of time, when they are there also, there's no sale which has taken place from then. So the sale has to be subsequent thereto. You have to therefore argue on this point that there will be a deemed sale. No, don't argue like that. There's just deemed sale. I'm giving you. No. You have to argue. You have to bring your case within the ambit that by operation of law, it will be a deemed sale. Now, where is the provision that it will be a deemed sale? Deemed sale also requires a statute. Where is the deemed sale?
Moment the status is saying
Ah.
whatever stock is available.
Because he became on 1/9. Now, these are one you also need to think about. These are goods which are goods lying where tax has not been paid. Now, a very important aspect also happens. By operation of this amendment, if he sells it, he doesn't need to pay. You see, the point is first point. It is not in the second schedule. It is in the fourth schedule. So then if he is selling it by operation of this act, you now hold it that he becomes the purchaser by operation of this law. If he becomes the purchaser, if there is a sale to the retailer, it becomes free, no tax. But changing the point, unless there is a deeming provision by which that would be considered, any goods which are lying out there would be considered. Think about this. This is a very interesting aspect.
My lord, in page 22, my lord,
Ah.
that notification, my lord will see,
Yes.
fourth paragraph. My lord.
Hmm.
Whereas it is deemed necessary to regulate the manner in which ad valorem levi and state VAT on such transitional stock of liquor which has not already been subjected to excise duty and VAT. So, my lord, it is referring to the stock that was bought from manufacturer to the bonded warehouse, which has neither suffered duty or VAT. Because for VAT also, my lord, a sale has happened.
No, duties is different. Duties is on a very different aspect. Duties because he as a bonded warehouse keeps it on the basis that look here, I am keeping it. Therefore, they give a bond. I am keeping this item out here, and we will pay you if there is a need. And as such, I am giving you a bond. The moment he becomes a warehouse, wholesale warehouse also, his liability to pay it continues. Taking into account there is already a liability to pay the moment he has brought it within the ambit of the bonded warehouse. I think that is what
Yes.
Justice Arun Dev Chaudhary's judgment must have been. For duty, there is no problem. But for tax, the problem arises is how do you have a deeming fiction by which it would be deemed to be a sale then when you are having this act prospective? Because this needs to be thought about properly, taking into account that all the goods which were lying out there would become free. Huge amounts.
Prior to 190.
A serious thought, Mr. Gogoi, not like this, by bringing some joint commissioners writing a letter like this. His case is protected, but your case is not. Let me do one thing. I would not finish it off today, taking into account that it's a huge amount of revenue will be involved, and this will have a castigating effect here. We'll vacate as regards excise, they have to pay it. We'll vacate that order. But I'll point out the query. And then you find out what can be done, because otherwise it will have a huge, because till now also there were, because I have delivered 2-3 judgments out there on this point, on this notification. One was pertaining to where Mr. Pranbora appeared as post.
For renewal of
One
license.
was where Mr. Indranil Chaudhary with NJ Khatonia appeared. There are 2 series judgments I have delivered on this 1629-6. But this is an interesting point. Okay. Leho. 7, it has been vacated, na?
7 vacated. My lord.
This must be my judgment as well. What is this? Motibul Hussain Hazarika is what? Is that the other one?
Where it was said that excise duty needs to be paid even for unsold stock.
Because the excise duty is leviable from the point the moment it
It is produced.
comes out from the manufacturer. Both the writ petitions are interconnected as they raise the issues, similar issues. Now, both the writ petitions raise similar issues. The question as regards the payment of the excise duty is settled by the judgment of the learned coordinate bench in the case of Motibul Hussain Hazarika versus State of Assam, reported in 2024 SCC Online, Gauhati, GAU 1459. And as such, there is no question of granting any stay in respect to the recovery of the excise duty. It is noticed that in WPC number 3025/2020, the learned coordinate bench have already vacated the stay for insofar as the excise duty is concerned. However, it is the further opinion of this court that in the case of the petitioner in WPC number 2653/2021 also, there cannot be a stay as regards the payment of the excise duty on the transitional stocks. The interim order which was passed on 9/4/2021, insofar as putting a bar on the levy of the excise duty, stands vacated. Levy for the purpose of recovery of the excise duty stands vacated. Be that as it may, in both the writ petitions, a question arises as to whether, by virtue of the amendment made to the Assam Value Added Tax Act 2003 by the Assam Value Added Tax Amendment Act 2016, which came into effect on 26/8/2016.
My lord, it came into effect from 1/9.
No,
Yes, my lord, your lordship.
no, Mr.
Your lordship will see the close.
Mr. I don't think I'm so wrong. Page 53. Look at page 53.
53, my lord.
It shall
C.
come into force on such date the
State
state
as
government
is
may
so
by
may by
notification in the official gazette appoint.
There must be this another notification.
There's another, which
Yes.
came into effect on
1/9.
1/9/2025. 2016. Be that as it may, a question arises as to whether, by virtue of the amendment made to the Assam Value Added Tax Act 2003 by the Assam Value Added Tax Amendment Act 2016, which came into effect on effect on 1/9/2016, would permit the respondents to seek recovery upon the transitional stock prior to transactional stocks which were paid, which were kept in the then bonded warehouses of the petitioners, which subsequently, by virtue of the amendment to, which subsequently became wholesale warehouses in view of the Assam Excise Rules 2016. With effect from 1/9/2016. Mr. O.P. Bhatti, the learned counsel, appearing on behalf of the petition, one of the petitioners, submitted that a perusal of section 10(1)(b) (1)(c) and 1(d) of the Assam Value Added Tax Act 2003 as amended by the Assam Value Added Tax Amendment Act 2016 would show that the said act, the said amendment, which would come into effect, which would come into effect on 1/9/2000, which came into effect on 1/9/2016, would render the wholesale warehouses, which the petitioners are, post 1/9/2016, liable to pay tax. But however, the said Amendment Act, or even the amended provisions of subsection 1B, 1C, and 1D of section 10 of the Act of 2003 do not take care, would not be applicable in respect to those transitional stocks which were kept in the bonded warehouses, as it kept with the petitioners in the which were kept in the bonded warehouses of the petitioners, as it then was prior to 1/9/2016. He further submitted that Mr. B. Gogoi, the learned Additional Advocate General, as well as the Standing Counsel of the Finance Department, Finance and Taxation Department submitted that he would look into the said aspect. It is also the opinion of this court that this court also would ask the learned Additional Advocate General to look into the aspect as to whether, by virtue of subsection 1B, 1C, and 1D of section 10 as amended by the Assam Value Added Tax Amendment Act 2016, whether those transitional goods which were in the bonded warehouses of the petitioners prior to 1/9/2016, if sold subsequently, if sold after 1/9/2016, would attract any tax. Because there cannot be a tax. Can there be a tax? Because you see, the point has been changed. What do you say?
My lord, there would be the tax, but if.
How can there be a tax?
These are not sold. In that case, there cannot be a tax, man.
You see, they have put the point where? They have put the point with the wholesale warehouse. Unless, if we come here, 1C, in such item, importer so-and-so inside the state, he shall be liable to pay tax. Now, if he says a wholesale license or any other dealer who purchases such items from such seller shall be liable. Now, the seller is who? Manufacturer, bottling unit, distillery, breweries.
Right.
So they become a wholesale warehouse.
Another point, my lord, this is applicable to import if it comes from outside the state.
No, see 1B.
1B is for inside.
That is what I'm saying. If the first sale of such item is made by the manufacturer's bottling units, distilleries, breweries located within the state, the wholesale warehouse licensee or any other dealer who purchases such items from such seller shall be liable to pay tax on the purchase of such items on the price consideration, including excise duty. So this comes into effect after so and so.
Yes.
Now who becomes the seller are those. So 1B comes only in respect to those. Seller. Now kindly see. Notwithstanding anything contained in this act, in the case of potable mentioned in the fourth schedule except country spirit, if the first sale of such item is made by an importer, wholesale license inside the state, he shall be liable to pay tax on the sale of such items. So I think once he will take it, we don't require this one. Then. Once he to last story to this court would also like to observe, ask him. I think once he will take it, if they sell it. But what about the earlier one? Unless there is no sale, you cannot impose. List this matters again when?
will give me at least 2 weeks time.
2 weeks, no problem. Bihu?
My lord, in view, I would not be available from 3rd to 20th. So that either before it or afterwards.
23rd April.
Much.
Second portion to Nalagi once.
May I please, Your Lordship? My lord, I may be allowed to withdraw this.
Ms. So-and-so, the learned counsel appearing on behalf of the petitioner submits that she has instructions to withdraw the instant writ petition. Taking into account the above, the writ petition stands closed on withdrawal. Mr. S.C. Kyle appears on behalf of the respondents. CGT. Respondents, CGST. Customs.
Lordship, in this case, we have filed affidavit today, Lordship. In this case, we have filed affidavit today only, Lordship.
You have filed the affidavit
Lordship.
today. It has been submitted that an affidavit in opposition has been filed. The competent authority for land acquisition have filed an affidavit today. And Mr. D. Burwa, the counsel appearing on behalf of the petitioner, submits that he has duly received the same. List this matter again on 4th of May 2026. The registry shall bring on record the said affidavit filed by the competent authority for land acquisition. Interim order passed earlier shall continue till then.
Last time, I was supposed to bring some order, observation made in another court by your Lordship.
What is that?
That is Lordship's order. In another case, similar situation, another case, Lordship has made some observation. In that case, my lord.
What is that?
Similar situation, in that case, my lord, already authority has filed the particular proceeding, particular proceeding against the.
No, what has happened to that matter?
That matter is.
I think I have disposed of.
No, that is pending, Lordship.
Why?
It is
It was a fight between Mr. D. Das and Mr. P. Mohanto, isn't it?
Yes, yes, yes.
I remember
That is.
where Mr. P. Mohanto's client has taken, he was the respondent number 7 in that proceedings.
Yes.
It's okay.
Okay.
What is this? What do you want?
My lord, in this case, my lord, petitioner's son died due to drowning. My lord already passed an order, case 52.
Here, my lord, petitioner's case cannot be considered because of want of death certificate, my lord. That report yesterday has sent to me.
Want of death certificate. But I have an PM report, police report.
proposal for sanction, my lord, death certificate is a requirement.
Yes, where's the death certificate?
In writ petition also.
Where's
he
the
has not-
postmortem report?
PM report, my lord, page 43,
Page?
page 43.
What did he say? As per the inquest report, dead body, Chalan and forwarding center. What is the cause of death?
Cause of death, my lord, page 47.
Decomposed. Ribs and cartilages are healthy, composed. And right-sided forever, which is divided and devoid of self and so labor and animal for police. Where?
My lord, page
No negative, what? Around the Iman. What is the tunnel wounds? Case properly found, packet in a black colored plastic. Opinion regarding cause of death is kept pending. So as of now, there is nothing. Police saying this would not do.
Page 40 is the police report also, my lord.
Police report is not there. Without the death certificate also, why don't you have the death certificate?
Page sometime may be given. I will-
Then
In fact, my lord, our officials has came to their house also, my
Ah.
petitioner's house on field report.
and
In
you
that-
have not
in
been
that- in
able to
that-
produce.
the
So
Second page is the, my,
you are entitled, he is only entitled to only if there is a death.
that
dismiss-
certificate is requirement, my.
We dismiss his case.
No, my date is there, my lord.
No
After
case.
20 days, his body was recovered.
So what? He may have jumped into the river,
Son was died in the year 2017, my lord.
and then
The 17 yet to that
no,
certificate
no.
is.
My lord,
Heard Mr. M.R. Kandakar, the learned counsel appearing on behalf of the petitioner. Mr. M. Borman, the learned counsel appears on behalf of the respondent numbers 2, 5, 6, and 7. Miss N. Bordler appears for the respondent number 3. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in not granting the ex gratia payment of ₹4 lakhs to the petitioner in terms with the notification dated 27/7/2011. It is the case of the petitioner that the petitioner's husband,
no,
Son, my
petitioner's son.
17
petitioner's son, petitioner's son, on 24/8/2017, went to the Brahmaputra River for taking bath during floods and he died. And as a result, he died due to drowning in the river Brahmaputra. Full stop. It is also mentioned that the body was recovered only on 13/9/2015. 17. The postmortem was carried out, but however, the postmortem opinion was not given on account of the toxicology examination report not being received. There's nothing on record that the petitioner thereupon took any steps for obtaining the postmortem report. It is further relevant to take note of that in the year 2023, and more particularly on 17/6/2023, the petitioner submitted a representation for grant of the ex gratia compensation against her deceased son, who died on 24/8/2017 due to drowning in the river Brahmaputra. But as nothing was done, the present petition was filed. it is seen that the materials and records show that on 19/10/2023, the notice was issued. In pursuance to that, today Ms. M. Borman, appearing on behalf of the state respondent, submitted that for the purpose of grant of compensation under in terms with the notification dated 27/7/2011, there's a requirement of producing the death certificate as well as also confirmation of the date of death. However, both being not available, the question of considering the petitioner's representation for grant of ex gratia does not arise. In that regard, the learned counsel has placed before this court an instruction which is kept dated 10/3/2026, and which is accompanied by the report submitted by the Circle Officer, South Solomon Revenue Circle. Both are collectively and kept on record and marked with the letter X. Pusto. Why on earth did you send a 7-year-old child to the river? Why?
That too in the flood situation. That too in the flood situation.
That too in a flood situation, you send the 7-year-old to take a bath. Pusto. Taking into account that the mandatory requirements of submitting the death certificate as well as the date of death, confirmation of the date of death have not been placed, comma. This court cannot issue a writ upon the respondent authorities to direct them to consider the petitioner's application without the said documents. This court also finds it very pertinent to take note of that the postmortem report which have been enclosed also do not mention any reason for the death. And the petitioner, since 2017, have not thought it prudent to even apply for the updated status of the postmortem report. Considering the above, this court does not find the present petition to be a fit case for passing any directions as has been sought for. Accordingly, the petition stands dismissed.
Progress.
Number 5 and 6 to the board of directors of the society, Lordship. However, in the meantime, Lordship, the elected members, they have been disqualified in item 47 and the board has been dissolved, Lordship.
So 47, we are taking it. Are you? What are you challenging in this petition?
Lordship, in this petition, Lordship, item 11, item 5 and respondent number 5 and 6, Lordship, they happen to be, what happened in this case, Lordship? They are the builders. The builders have built a society in Avoidpur, Lordship. Subsequently, they have purchased their own building in that project and they become the members of the society. And later on, they have been elected as president and secretary of the board of directors. So the construction of the society was not complete as the common area of the society have not been transferred to the society by the builder. So that one transaction is left out also. And secondly, some other constructions were also going on and there were some violations. So we have made some complaints before the NGT also. NGT has given some directions. So Lordship, what happened?
Who has given direction?
NGT, National Green Tribunal. Those directions were given to the builder. So presently the builder, 5 and 6, they are the residents of the society, members of the society, as well as they are the builders of the society also. So Lordship, in the interim, what happened, Lordship, they have convened a AGM in the society. So that AGM has been challenged before the registered cooperative societies. And ultimately, the registered cooperative societies gave a verdict that there were inconsistencies with the agendas and the resolution. And due to presence of a non-member, the entire board has been dissolved and one-man committee has been appointed. Lordship. So that is under challenge by the respondent number 5 and 6 in item 11 as a petitioner in item 47, Lordship.
You are the builders.
I for the society members, Lordship.
You are the petitioners here.
We are the petitioners, Lordship. We
You
the
are
members of
challenging the
society.
one-man committee.
Lordship, one-man committee is in item 47. We are basically taking item 11 now, Lordship.
Okay. 11, what are you challenging?
We are challenging the election of respondent number 5 and 6 as the board of directors of the society.
What remains? One-man committee has been appointed.
Lordship, one point is still surviving with respect because otherwise this writ petition has become infructuous since society has been dissolved. But Lordship, as on date, there is a transaction which has to be the common areas of the society that has not been transferred by the builder. A sale
Rera,
has to be executed. by the-
Rera.
We have already approached the RERA, Lordship. We have already approached the RERA.
Then why are you filing this when you are approaching the
No,
REPA?
subsequently, we have approached, Lordship. Previously, we have.
We close this. Art Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. S.K. Talukder appears for the respondent numbers 1, 2, and 3. None appears for the other respondents. The petitioners herein have assailed the orders dated 29/11/2022 passed by the respondent number 3, as well as the order dated 25/4/2023 passed by the respondent number 2. Wherein it was held that the private respondents had no pecuniary interest in the affairs of the society. And as such, they were not disqualified in terms with section 37C and 43 of the Assam Cooperative Societies Act 2007. Inasmuch as they were the bona fide shareholders of the society. It is further relevant to take note of that in the meantime, an election was held. An AGM was held. And in the said AGM, the private respondents have been elected as the board of directors of the said society. Be that as it may, the board of directors of the said society be that as it may, the AGM was nullified. It was nullified. No?
Subsequent AGM, they have subsequent AGM.
AGM was nullified. Was nullified by the respondent number 2 by an order dated 10/9/2025, and a one-man committee was appointed under section 41(6) of the Assam Cooperative Societies Act 2007. Taking into account the above, the cause of action for the present writ petition no longer survives. Accordingly, the writ petition stands closed.
Right.
Stands closed without prejudice to the rights of the petitioners. before any other form. 47 will take it later. Yes, what is this?
In this case, senior counsel, Mr. Kishidas was there, but due to his inability, he cannot appear. And the matter already informed to the petitioners. They are got some time to engage some senior counsel.
What do you want now?
Some time maybe allowed, because they
Who? Have they issued the notice?
yes.
Where is the notice?
It was alia notice was issued,
Now,
at present, no notice was issued,
then
the
why you are coming before this court?
because the police personnel threatened them to evict
Huh?
that matter flat.
What?
The police personnel
Huh.
earlier the earlier notice was issued that was set aside by the Board of Revenue, and it was directed to regulate the petitioners. That is page 65, start from 65. And the operative part 68.
Land is in tribal belt.
They said they made this within the tribal area, but
Huh? Tribal belt.
may not be, but
Huh? Then tribal belt also, I have passed an order now. We'll follow as per that. Where is that judgment, my order? Tribal belt. Giving them the opportunity.
it is rehabilitation. It was directed to rehabilitate the petitioners.
River eroded, that scheme has already, that scheme is no more there. I will have a notification equality. They can very well apply under the Bosundhara laws.
Right. Tribal belt is different. Tribal belt was, there was a direction passed by the Supreme Court of one. Anyways, if you want to vacate them, do it as per following the procedure.
Earlier, it was directed to rehabilitate the petitioners.
By?
Any land because we are river eroded person. And it is admitted fact that we are river eroded. So alia.
So if you are river eroded person, you have to apply as per the land policy.
Yes,
Yeah, have you applied?
no, man.
Then this can't happen like that. No. Now, heard Mr. D. A. Kayamdel and counsel appearing on behalf of the petitioner. Mr. Ms. N. Bordley appears for respondent number 1. This is in Boroland. Boroland, and what right do you have? Where is BTC?
Their name has not been shown, they are party.
There, BTC is there.
Our name is not shown in the coastal.
Huh? BTC. Ms. N. Chaudhary appears for respondent number 2 and 5. 4 is not under you.
Is he no?
3 and 4,
Huh? 2 and 5. And Mr. H. Burwa appears for respondent number 3 and 4. Apprehending that the petitioners would be evicted from the land in under their possession. The petitioners have approached this court by filing the present writ petition. First, it is the case of the petitioners that the petitioners were earlier residents of village Dhankanagar, P.O. Khagrabari, P.S. Dolgaon in the district of Kokrajhar, Assam.
Dhaligaon.
Huh?
Yes, Dhaligaon.
Dhaligaon. District, Kokrajhar, Assam. On account of erosion of the river A-I-E, in the devastating flood of the year 1988, the dwelling houses of the petitioners were damaged and destroyed. The petitioners thereupon took shelter over the government land covered by Dag number 53 by constructing temporary straw chali houses situated at village Baikun PO and PS Dhaligaon under Sidli Revenue Circle in the district of Sirang, BTC, Assam. Full Eviction notices were issued against the petitioners in the year 1990. However, the petitioners thereupon challenged those eviction notices in the proceedings. Before the Assam Board of Revenue under Section 169B of the Assam Land and Revenue Regulation 1886. By an order dated 2011 to 1991, the learned Assam Board of Revenue interfered with the notices issued. And directed the Deputy Commissioner to consider the prayer of the petitioners and submit report for their rehabilitation. With a direction to take action in the matter of rehabilitation of the petitioners. The petitioners thereupon, on various occasions, requested the Revenue and Disaster Management Department, as well as the District Commissioner, for granting rehabilitation to the petitioners by issuing them patta. However, that was not considered. In the year 2023, the petitioners could come to learn that a move was made on the part of the district administration along with the BTC to remove the petitioners, to evict the petitioners. And it is under such circumstances the petition has been filed. This court, it is relevant to take note of that by an order dated 22/9/2023, this court issued notice and further directed that the petitioners should not be evicted from the land under their occupation without following the due process of law. More than 2.5 years have passed by, but the respondents have not filed any affidavit or placed any instructions before this court. This court have also perused the writ petition as well as the notices which were issued against the petitioners. These notices were issued in terms with Section 165 of the Assam Land and Revenue Regulation 1886, meaning thereby that steps were being taken in terms with Chapter 10 of the regulation. The petitioners had also filed an appeal, their appeal under 169 of the regulation before the learned Assam Board of Revenue. This court have also perused the judgment of the learned Assam Board of Revenue, wherein the learned Assam Board of Revenue took into consideration that the petitioners had approached, were occupying the said land on account of being victims of the floods of the year 1988. Be that as it may, the learned Assam Board of, it appears from the judgment passed by the learned Assam Board of Revenue that there was any steps taken, that the provisions of Chapter 10 of the regulations were taken into consideration. It is also relevant to take note of that the petitioner, on the basis of the judgment passed by the learned Assam Board of Revenue dated so-and-so in Revenue Appeal number so-and-so, have been representing before the concerned respondent authorities seeking rehabilitation. Which, however, have not been taken into consideration. This court now finds it very pertinent to take note of that as the instant writ petition was filed on the ground of an apprehension of eviction, and the law being well settled that any eviction being carried out has to be done so by following a procedure mandated under law. In that regard, this court finds it relevant to refer to an order passed by the refer to a judgment and order dated 29/2024 passed in the case of Jahirul Islam Chaudhary and 22 others versus State of Assam, reported in WPC number 4818/2024, whereby this court had passed certain directions taking into consideration certain observations made by the Supreme Court in the order dated 3/2/2020.
Yes, sir.
was paragraph number 6 to 11 of the said order judgment being relevant is reproduced hereunder. And it is the opinion of this court that the petitioner herein also would be entitled to similar directions. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The petitioners herein are given the liberty to submit representations before the District Commissioner, Sirang, within March 31, 2026, along with all supporting documents claiming their right to remain in possession of the lands in question under their occupation in question. Number 2, the District Commissioner Sirang is directed that upon receipt of the said representation to decide the claims of the petitioners by giving them an opportunity of hearing. The hearing, personal hearing, which the petitioners would be afforded, the petitioners who submitted the representation would be afforded, shall be done so either by the District Commissioner or the Co-District Commissioner, as the case may be. Next, the District Commissioner Sirang or the Co-District Commissioner shall pass respective speaking orders as per the provisions of law. Next, this court further observes and directs that in the circumstance, the orders so passed by the respondents, by the District Commissioner or the Co-District Commissioner, as the case may be, are not favorable to the petitioners, for a period of 30 days from the date of passing of the order, speaking order is served upon the petitioners, no steps for eviction be carried out. Next, it shall be within the jurisdiction and authority of the district commissioner and or the co-district commissioner, as the case may be, to fix the date of passing of the speaking order. And if on the said date the speaking order is passed, it shall be deemed that the petitioner have notice about the passing of the said order. No, this is a tribal belt order. Oh no, that is different. Tribal belt item number 1 is another, that is another question. That is on a application under 163 annual patta and all. That is a different thing. But this is different. This is, I have already passed an order. In fact, at that point of time, the Advocate General had appeared in this matter, and accordingly that. Therefore, I have quoted that portion. And that was specifically regarding chapter 10. Yes, Mr. Islam.
The respondent has filed affidavit here, that's it. The opposition filed a reply to which time granted.
Who are you?
Within the Damodar Sangha Association here, that's it.
Huh?
Damodar Sangha, they
Ah.
are within the president of Damodar Sangha.
Then somebody else, it's a private dispute between you and respondent number 6 and 7. Why this court?
Yes, that is that we have raised the maintainability issue.
Then
Not private,
go there, civil court. This type of cases cannot be allowed.
private dispute here, that's it. They are
Dismiss, withdraw, liberty. Which one?
not private dispute. No private dispute is not.
Dismiss. Heard Mr. S. Islam, the learning counsel, appearing on behalf of the petitioner. Ms. S. N. Bodlo appears on behalf of the respondent number 1 and 2. Mr.
3 and 4.
H. Sharma appears for the respondent number 3 and 4. You are for?
I am for 5, 6 and 7.
Mr. So-and-so appears for the respondent numbers 5, 6 and 7. The present petition has been filed by the petitioner challenging seeking directions upon the respondent authorities not to use the Chatoli land for any other purpose, and further seeking a direction upon the respondent authorities to demolish or remove the illegal construction done by the respondent number 6 and 7 on the Chatoli land. That is in Dag number 174, covered by Patta number 04 of Sariali T State under Tinsukia Revenue Circle. A perusal of the petition reveals that the dispute between the petitioner as well as the it is primarily a dispute between the petitioners and the respondent numbers 5, 6, and 7. And the respondent authorities have been unnecessarily dragged in order to avail the public law remedy. Considering the above, it is the opinion of this court that this is not a fit case for being entertained under Article 2 to 6 of the Constitution. Accordingly, the instant application stands dismissed. Be that as it may, this court, however, grants liberty to the petitioners to avail remedies before the competent civil court, if so advised.
Okay.
May it please, your lordship.
What is this?
My appeal was dismissed on the point of time limitation, my lord.
Dismissed for?
Limitation, my lord.
What limitation?
So you will see the operating part at page 103, my last page, my lord.
What order is this?
Is appellate order, my lord. Appellate order, my lord.
Under what provision?
Finance Act 1994. Finance Act 1994, my lord.
Then
The facts are like this, my lord, 2009, 20.
let's see the order, appellate order,
Lordship, the operating part.
order in appeal.
Yes, my lord. The operating part is at page 103, my lord.
Huh?
Last page is the operating part, my lord.
103. Going by the above section, demand of say the period of 2 months in the instant case would have expired so and so, whereas the appeal has been filed on so and so. Given the 1 month extension that the Commission appeals can allow for expired on so and so. Further, I examine the delay in terms of the judgment of the sumoto so and so. Notwithstanding the actual period in the event in the event of the actual prevalence of the in 90 days, that longer period shall apply. At the date of expiry, the limitation in the instant case is within period considered by this. Session. Interfere. Let him go there. Heard Mr. R.S. Mishra, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent. Numbers 1, 2, and 3. 1, 2, 3, and 4. The present petition has been filed challenging the order in appeal.
49.
Number 513/GHY-A/COMMR/ST/DIB/2023 dated 14/9/2023. Hereinafter referred to as the impugned order, whereby the application filed for condonation of delay. You have filed a condonation of delay. Was rejected on the ground that there was a delay of 17 days in filing the appeal. This court have duly taken, where is the application for condonation of delay?
Page 87, my lord.
Is there a power to condone the delay?
1 month power is there, my lord.
Huh?
1 month power. 1 month power is there.
1 month. So it comes within 1 month.
But the appellate authority was of the view, my lord, that since the Supreme Court has granted 90 days time, Supreme Court, beyond that he has no power, my lord.
No.
Section 85(3).
Huh?
Section 85 of the Finance Act.
85(6).
85(3)(a), my lord. I have quoted in my petition, my lord.
Where?
Page 11, paragraph 16, my lord. Subsection 3(a) proviso, my lord.
Within 2 months.
Thereafter proviso is there further 1 month.
The materials on record, the brief facts which led to the filing of the instant petition is that an order was passed order in original number DIB/JOR/ST/01/21-22 dated 12/5/2021 was passed against the petitioner, passed by the Assistant Commissioner, Central Goods and Service Tax, Jorhat. Whereby service tax as well as penalty and interest have been imposed upon the petitioner. The petitioner thereupon filed an appeal on 17/6/2022. In terms with section 85 bracket 3 capital A of the Finance Act 1994, the period for filing an appeal is 2 months from the date of receipt of the decision or order of the adjudicating authority. It is also relevant to take note of that the proviso to section 85 3A of the Finance Act 1994 empowers the Commissioner of Central Excise Appeals to condone the delay if filed for a period of a further 1 month. Next. In terms with the above, as the order was received by the order in original was received by the petitioner on 21/5/2021, isn't it?
22/5, man.
Huh?
22/5, page 71.
When did you get it?
I get it 22/5/2021, my lord.
22/5/2021,
5.
isn't it?
Yes, my lord.
The appeal ought to have been filed on or before 22/7/2021. 2 months now.
Fine.
However, the appeal was filed on 17/6/2022. At this stage, it is also very pertinent to take note of that during that period, on account of the COVID pandemic, the Supreme Court had extended the period of limitation by passing an order on 10/1/2022 in writ petition C number 3/2020. Paragraph number 5, Roman 1, Roman 2, Roman 3, and Roman 4. Roman 2 and Roman 3. Of the order dated 10/1/2022 being relevant is reproduced herein under page 84-85 of the. From a perusal of the above order, quoted order, it would be seen that where the limitation would have expired during the period from 15/3/2020 till 28/2/2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1/3/2022. It is also mentioned that in the event of the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that longer period shall apply. Taking into account the said directions, as the order in original was passed on 21/5/2021, the petitioner had time till '35, na?
29/5. 29/5 is 90 days.
1314. Why 29/5?
Sorry, 30, I'm sorry, 30.
35. 35/2022 to file the appeal. It is very pertinent to take note of at this stage that, taking into account the order passed by the Supreme Court dated 10/1/2022, the provision of section 85(3)(a) has to be therefore read as the period ending has to be read in the case as in the facts of the instant case as the period ending on 30/5/2022. The proviso to section 85(3)(a) of the Act of 1990 of the Finance Act 1994 empowered the appellate authority to condone the delay for a period of 1 month. And in the opinion of this court, this period of 1 month as permitted under the proviso to section 85(3)(a) of the Finance Act 1994 would have empowered the Commissioner Appeals in the instant case to condone the delay up till 30/6/2022. In the instant case, it is seen that the Commissioner Appeals was under the impression that the Commissioner Appeals had no power to condone the delay. It is the opinion of this court that the order therefore, it is the opinion of the court that the order therefore, order impugned, suffers from not only non-application of mind, but also failure to exercise a jurisdiction conferred upon the Commissioner of Appeals under law. Accordingly, this court therefore interferes with the order dated 14/9/2023. Impugn order dated accordingly, the instant with petition stands disposed of with the following observations and directions. The impugn order dated 14/9/2023 is set aside and quashed. Number 2, this court have also perused the application filed for condoning the delay of 17 days. And it is the opinion of this court that the same constituted a sufficient cause. Accordingly, this court therefore condones the delay in filing the appeal on 17/6/2022. Number 3, this court therefore directs the Commissioner Appeals is directed, that is the respondent number 4 is directed to decide the appeal on merits without insisting on the question of limitation. Yes, Mr. J. Ahmed.
My lord,
What is this?
in this case, my lord, some portion of land has been acquired from the DAG number. Kolkata land has been acquired, and remaining land is still there. But they are occupying the entire lands, and the improved water loss kindly see page 70.
Yes, who appears? We set aside. Who are you?
In their name.
Huh?
Apply is in their name, my lord. Before passing this order, my lord.
No, 116 cannot be done. You may remove somebody's name from the mutation records. That is the power under 116. The power is not for divesting him of his rights. There are many judgments I've delivered. How many judgments I've delivered?
Third paragraph. Paragraph. It says, madam, it will also come to para 3, madam, of the imperial judgment. Where is married? Where is, as per circle officer, Gauhati Revenue Circle, report land measuring 1 bigha 1 kotha covered by DAG number 1217 village Bhamani Medium Moja is under the position of Lloyd is a patta land of Ranagusami. The land is under the position of the oil mine. Illegal position.
Who?
If this impin order also is cost mile, land will be under the position of the oil mine.
Who?
So for that mile, they have to come, will have to go for a civil suit mile for eviction of this mile.
But how do you pass this order? How can you make it government?
Suppose if this order has been set aside by this honorable court, the land will be still remain in the position of the.
Who what? Who what? So tomorrow, what you are trying to say, when a particular person is the owner of the land, well, let me tell you, you are the owner of the land, and Mr. J. Ahmed had encroached upon your land. Okay? You have a permanent periodic patta in your name, and Mr. J. Ahmed encroaches upon your land. Then, Mr. J. Ahmed files an application. See, I am in possession. Make it government and give me the settlement.
That's, I'm not into that, my lord.
Does the DC has the power?
No, but I'm into not that. I'm saying, my lord, the possession, my lord.
How does it relevant? If it is in possession of oil or not, how does it make it relevant that you can make it the government?
They have filed an IA for evicting the oil and others from the land mines.
Who? They file eviction.
I am listening in case, here I is there, I am not going to press this petition.
You also know not to make this type of prayers before me.
I'll not press this petition, my lord.
Because my instruction also says that the land is under possession of the,
So what?
I'm only into that matter.
Hardly matters. And who is appearing for the other side?
I am appearing for small industries, my lord, respondent number 5.
Who are you?
But we had allotted the land to, my lord, the oil.
How do you allot the land to oil?
My lord, there are two, my lord, notifications, my lord. Initially, my lord, 30 bighas of land was acquired in favor of the industrial estate, my lord. So, my lord, when, my lord, the DC's impugn order was passed, all the facts were not before the DC. Subsequently, we, my lord, traced, my lord, another notification, my lord, for acquisition of another 7 bighas of land. That is a separate law. Out of that 7 bighas, my lord, 5 bighas were handed over to oil. That was not before the DC, man.
I'm
And
not
this,
concerned.
this dark,
Here you have made the land government.
yes,
How? It is a patta land belonging to him.
yes, but this dark, my lord, 1217 number dark, has its origin in dark number 330, man.
You do whatever you feel
Yes.
like. That is a different thing. That is for cancellation of the patta.
Yes.
That is 26. That is, you have to go as per 26, regulation 26. We are not concerned with that.
Yes.
We are concerned out here that
Yes.
you are doing it under 116. You cannot do this.
Thing is that this 1217 melod tag was originally 330, and out of 330 melod we acquired 4 kathas of land.
You have
So-
filed affidavit.
Yes, and
Very well.
since 1950,
You have filed affidavit. It's okay. We admit this petition. There's a stay.
My lord,
There's a stay.
Yeah.
We meant it till the disposal of the writ petition. Come up for hearing in the year 2035. Not before. Okay. Pleadings being complete, this and a question of law of importance having arisen. This court admits the writ petition, issue rule. There is no requirement of any fresh steps to be taken. List the matter for hearing in the usual course. Interim order passed earlier on 4/10/2024 stands extended till the disposal of the writ petition.
only our problem.
I stands closed.
Only our problem is, my lord, if there is a long delay, then we'll be suffer.
Why? There's a stay to that order.
But they are policing the land.
So you go and file. It shall not be a bar on the part of the petitioners to file a suit for eviction of, file a suit for eviction. Don't make unnecessary submission, Mr. Das. First of all, you should know the law, then do it. I'm only concerned with 116. You cannot exercise power under 116.
I admit that, man. Thing is
If
that,
you have you looked into what is
yes,
116?
regarding possession, man.
No, it doesn't say possession. See, do you have the book or not?
Yes,
Or making that submission out of the wind? Have you looked into 116? Don't have the book and making submissions. As does the counsel appearing from so and so has appeared before this court without a book and does not know what is mentioned in section 116.
my lord, when, my lord, if
When you don't have the book, don't make a submission. before.
I'm bringing the book.
Don't make. Now, next. You have a very good case. Go, eviction. And this is state till 2025.
Land giving case, we already filed land giving case.
You go for land grabbing.
I already filed here.
Oh, fantastic. Go ahead.
My lord, matter goes back to 1970s when the selling operation was done.
Non-finalization of the sealing case.
My lord. In fact, there was a final order passed in 1993. Annexure 24, page 71. And based on that, my lord, a certain portion was to go for selling and the balance portion was to be returned to the landowners. Now thereafter, after we filed the land statement, what they had done is that the matter was kept pending for a long time, and in 2005, my lord,
I can't.
they
pick
again
up.
sought to
No, I
reopen
can't
it
pick
by.
up the- No, no, no. This, I can't. List the matter before any other court. This matter, I was consulted at one point of time. This is the land out there in this Dorong or?
Dorong, my lord. In fact, I was told that some other revenue matter lordship was consulted, not
No, no,
particularly
I
this matter.
remember this. Do you need the facts out here? I still remember vividly. Sealing the land, a lot of land has been taken on sealing. This person was trying his best to get the sealing out of there, that no steps have been taken, various representations filed, nothing has happened. Earlier, late KP Pathak was, yes, Kularanjan
My lord,
Pathak,
he
he was looking into
the-
the matter, then the matter came to me. Yes, next. Mr. Sharma, tell me.
May please, Your Lordship.
Ah,
My lord. In the instant case, my lord, the petitioner, he had constructed his dwelling house over his own plot of land at Gandhi Busti, measuring about 15 lesses out of total 1 kotha, 9 lesses. Covered by Dak number so Patna number 1, situated at Gandhi Busti, village Sohor Urubari Moja. By obtaining planning permit dated 27/9/2021 and building permission dated 27/9/2021. Now, as per law, my lord, and construction of the building has been completed up to 90, almost 90% completed. Now, what happened, my lord, actually what happened, dispute everybody over his own plot of land. Dispute in between the respondent number 8, respondent number 8, his elder sister. And his elder sister had constructed in front of his residential building. And this originally this plot of land belonging to their mother. Under Muslim law, mother during the lifetime of the mother lordship, what happened? The elder sister, by manipulating her like this way, 11 lessons of land was purchased from her mother by a registered sale. That I have nothing to say. During her lifetime, she had purchased. Accordingly, 11 lessons out of 1 kotha 9 lessons. Then, my lord, what happened? The defendant number 1 is the next brother of the respondent number 8, and
let us see the impugn order, Mr. Sharma. Which order we are referring to?
Lordship, can you say what happened?
Where is the impugned order?
Paragraph 2 on page number 5, madam.
Page?
Paragraph 2, page number 5.
Huh? Now, where is the impugn order of the
my-
mayor in council? 5/8/2024.
Pardon, madam.
Where is the impugn order?
GMC,
got it.
impugner, annexer,
Peruse the
last
memo
annexer,
appeal prepared by Nazrul
23,
Islam
my
against
lord.
the
Page
notice
119.
associated so and so whereby the
119,
appellant was directed to show cause by the NOC issued for purpose. Babia should not have been cancelled on the ground of cancellation of his mutation with the land. And the appellant. Okay. We set aside this type of orders.
My lord, actually what happened?
We set aside.
Uh,
We
yes,
set aside this
yes, my
impugn
lord,
order
This will be set aside.
till the disposal of the title suit.
No, actually, title seat was withdrawn by the
No.
President 5.
So then this order cannot remain.
She has withdrawn, my lord, but she has constructed.
Mutation cancellation has no relevance. Mutation neither confers title, neither
Yes, my lord.
grants a title. So therefore, the very basis on which 5/8/2028 order is passed is wrong.
After completion of the building,
Huh?
after completion of building, after assessment,
What is the
assessment
second
extending,
order 911?
they cannot issue any notice now.
In consideration, here this authority is of the opinion that Nazi is no longer the owner. My goodness. He set aside.
Lordship, may kindly see the building permission, Lordship, that is at page 100. If Lordship
Yes.
comes to the last column, Lordship will see the Doug number and Pata number.
Hmm.
So this particular building permission was issued against a particular plot of land, Lordship, bearing Doug number so and so, Lordship, of which he was the owner at that point of time. Subsequently, Lordship, that mutation was cancelled by the authority. I'm not on the mutation or cancellation of the mutation. Lordship, if the plot is not there, against which plot we are going to issue the building permission?
You have already granted the permission against the
Yes,
plot. The
yes.
plot has not lost its existence. Plot remains as it is.
Yes.
Now the question is only the mutation. His name is there on mutation. His name is not there.
No,
Is the question out there?
once mutation in his favor has been cancelled, Lordship, some other
Mr.
person is
Naik,
now the.
Mr. Naik, you are you are having a good standing in the bar. Don't make that submission. It's not befitting to make that submission.
No, my only understanding, Lordship, now.
Your only understanding is
Now
absolutely
somebody else is the owner of this plot of land, Lordship. And
You
no,
got to stay.
no case is
No.
pending.
You've got to stay.
No case is pending.
No, my lord, now.
Have you got to stay to these orders or not?
No stay order.
We stay it and issue rule. You complete your building, everything done.
Yes, my
Stay there,
Yes.
then sell it,
Yes.
and then you
Yes,
come
yes.
say that the reputation has become infractions. Instead of submissions in here, we at 2 o'clock, Mr. Kumar, Sharma, we
there
are
is no
going
table.
to set aside both these orders. Petition cancellation and his building permission has gone for a 6.
That is the only question, Lordship. Building permission means it's against a particular plot of land, Lordship.
I think 5 minutes is enough for this disposal, no? Okay, I have heard Mr. S. Sharma, the learned counsel, who is appearing for the respondent. Why are you fighting with your brother?
Actually, what happened? There are 4 brother sister. They fraudulently put their name in the next of kin certificate. I was deprived. So, Lordship, I came to the circle office. Then I have. Then I filed a title suit, Lordship, and then after that, order was in my favor. Then I applied for mutation.
Title suit, what happened to your title suit?
No, it is pending, Lordship.
My lord, title suit has been withdrawn by her himself because the injunction petition was rejected
Oh, it
against
is
it is in her favor. Title suit was withdrawn by her. Legal mutation was granted in my favor. Jamamandi recorded.
File was handed over in
Now-
the morning, today morning. So I just go through the.
Okay, you go through it.
I know the fact, but
But we stay these type of orders. These orders cannot be. But there was an interim order passed.
yes, Lordship.
Interim order, my lord.
No steps is having regard to the submissions made and the pack of circulars in the nation, no steps be taken.
Madam, I'm sorry, actually, the case was originally conducted by other counsel.
There was a stay.
On the last occasion.
There was a stay given on in respect to this. Madam, the thing is like this. You say that you are also have a right over the land.
Yes, Lordship.
Now he has constructed the building.
Yes.
Claim, file a suit. You have withdrawn it. Why have you withdrawn it?
Because, Lordship,
At this stage of evidence, my lord, she has withdrawn.
no, Lordship, some technical issue may be arise.
Did you withdraw with liberty? With
Lordship,
liberty or not? Where is the order? Withdrawn with liberty or not? Why are you asking the GMC council?
Sis, I'm just asking her.
Is it?
Because
Okay.
withdrawal, my lord, with a liberty to file suit.
Liberty taken.
There is an order.
Huh?
she has withdrawn the suit with a liberty to file a press.
Okay, madam. You listen,
With a liberty to file a press.
you have taken with liberty, am I told? So you file a fresh suit claiming right title and interest as well as for demand. You file another suit
Yes, Lordship.
pending. So that will be subject to the outcome of that suit.
Yes.
So these orders we need to set aside. Now tomorrow, if you win the case, you take that building also.
My lord, another point I want to make it clear. Lordship, I want to make it clear regarding the elder sister and my dispute. Orderly, everything is settled. She has constructed her own house of her own property.
Mr. Sharma, I'm not going to look into that.
Yeah.
I'm not going to look into that. It is a dispute by you and her. Both of you are having a dispute over the properties. The respondents out here thought it should not have intervened on the basis that a mutation is cancelled, so your right has gone.
Yes, sir.
The building permission has gone for a 6. That is wrong. So we set aside those two impugn orders.
Yes.
And both of your rights will be regulated as per the civil suit. You filed it.
Lordship, their mutation has been
You
cancelled.
give the number at 2 o'clock, you give me the number of the case. And then we'll take it up. We'll pass the order.
Lordship, their mutation has already been cancelled. Mutation order has already.
Madam, mutation order cancelled has no relevance to a construction of the building.
Yes, madam.
That's true. Lordship.
There is no relevance because a mutation does not confer title, a mutation does not extinguish a title. So therefore, it has no relevance. It is only for the purpose of collection of tax.
Yes.
Tomorrow, if you may out there, you may not be able to pay. But the mutation remains, if it is there, there's always a presumption that he has a title as well as also is in possession. Because these are the requirements under regulation 50, that these are the requirements. So therefore, ask your dear friend out there, she may teach you out there.
Lordship. Thank you.
Yes, for the respondent number 8,
We set aside this order.
The only thing, my lord, probably, my lord, since I have not yet filed, in fact, I was supposed to enter appearance today, my lord. In fact, I filed the workload number today. The fact remains, my lord. If your lordship probably inquired whether the cases are there or not. In fact, both the cases, there was a suit was withdrawn. It was withdrawn on 4/3/2023. Counterclaim was also withdrawn on 1/11/2012, 22. My lord. Now, the fact which is, sorry, my lord, 17/9/24 and 21/11/2025. Now, what has happened in this case, my lord? There were 4 siblings. Now, the petitioner before lordship, he initially obtained next of kin. There is a dispute in respect of the land. That is something there. Thereafter, my lord, he obtained an NOK from the official authorities disclosing that there are three siblings. Removing the name of the respondent number 8 there. And on the basis of that, next of kin, my lord, he obtained the mutation. And thereafter, it continued. Now, we have a share of land in that plot of land. So the suit was filed. During the proceeding of the suit, my lord, these things came into fact. My lord, we placed the objection before the authorities concerned. Thereafter, there was a hearing which took place before the deputy commissioner. The deputy commissioner, after giving a due hearing upon to the petitioner, my lord, cancelled the next of kin. And on the basis of, my lord, all these certificates were cancelled. The mutation was cancelled, my lord, because my name has to be incorporated there. So, my lord, ultimately the mutation, my lord, it was cancelled. Now the permission, my lord, so far the permission is concerned, my lord, there were deviations in the plan. And in fact, my lord, we are objecting to it in various quarters, my lord. We approach the GMD authorities, we approach the GMC authorities for violation of the bylaws, my lord, building bylaws. And in fact, my lord, the GMC authorities, my lord, issued notices to stop construction. That was not adhered to by the petitioner, my lord. And subsequently, my lord, after, in fact, notices were issued. It's not that, my lord, they said that it is the violation of principles of natural justice, but that is not true, my lord. In fact, he was given ample opportunity to defend his case.
He said,
Madam, you made a mistake in getting him. I'm to allowing him his petition earlier, which I was thinking of granting you some opportunities. That is also gone. Why did you get him? He's spoiling your case. You don't have spoiling. I have got him. Okay. We set aside these two orders. Heard Mr. S. Sharma, the learned counsel, appearing on behalf of the petitioner. Mr. P. Naik, the learned additional advocate general, appears on behalf of the respondent numbers 1 to 7. Mr. R. Day appears for respondent number 8. The present writ petition has been filed by the petitioner challenging the order dated 5/8/2024 passed by the respondent number 7, semicolon. The order dated 19/11/2024 passed by the respondent number 3, as well as the order dated 7/12/2024 passed by the respondent number 5. The materials on record show that the petitioner's mother, late Mahmouda Begum, was the owner of a plot of land at measuring 3.90 R covered by patta number 1, dag number 1110 of village South Soronia. It is the case of the petitioner that the petitioner's mother sold a plot of land at measuring 11 lechas out of 1 kata 10 lechas in favor of the respondent number 8, and the same was mutated in her name on 23/7/2007. The remaining land, which is at measures 18 lechas, remained with the mother of the petitioner. In the year 2007, the mother of the petitioner, along with the respondent number 8, jointly applied for a permission for construction of an RCC G+2 building over the plot of land purchased by the respondent number 8, and also a portion of the remaining land held by the mother of the petitioner, and obtained a no objection certificate for construction from the Gauhati Metropolitan Development Authority. On 4/7/2007, a permission was granted by the Chief Executive Officer of the Gauhati Metropolitan Development Authority for construction over the land covered by Dag number 110 11110. Is it right or wrong? What is the actual number of the 1110? A patta number. One.
Patta number 1.
As per the said no objection certificate, the permission was granted for construction of ground floor, first floor, and the second floor. On 17/6/2018, the mother of the petitioner expired, leaving behind two sons, namely the petitioner and one Nurul Ahmed, and two daughters, namely Jarjina Begum and Marjina Ahmed. It is the case of the petitioners that there was an oral partition made during the lifetime. The case of the petitioner that after the death of the mother, all the sons and daughters had mutually agreed and made an oral partition of 18 lechas of land covered by patta number 1 of Dag number 1110 and the structure standing thereon left by their mother. As per the said oral partition, 18 lechas of land was left behind by the mother of the petitioner. As per the share under the Mohammedan law of inheritance in presence of some well-wishers and the petitioner and his brother, being the sons got 6 lechas each, and the respondent number 8 and Jerina Begum got 3 lechas each. This oral partition, as claimed by the petitioner, was done on 5/8/2018. A suit was filed by the respondent number 8, suppressing the said oral partition, which was registered and numbered as title suit number 258/2021. And along with the said suit, an injunction application was also filed. However, no injunction was granted. The petitioner, who was the defendant number 1 in the said suit, had filed a written statement cum counterclaim in the said suit for declaration of his title, right title and interest over 15 lechas of land out of the 18 lechas, as well as for confirmation of possession and permanent injunction. The said suit filed by the petition by the respondent number 8 being title suit number 297/2022 was withdrawn by the respondent number 8, and the counterclaim, however, was pending. Is pending.
Was pending, my lord, during the pendency, it is withdrawn later withdrawn by the
was pending
by the petitioner, my lord. After their withdrawal.
Huh?
After their withdrawal of the suit, I have also withdrawn during the pendency of this.
But as per this petition, it is pending, it is mentioned.
It was withdrawn on 21/11/25.
Till the date of filing, the counterclaim was
Okay.
pending.
Was pending. However, the counterclaim filed by the petitioner continued to be, was kept, was continued with by the petitioner till the filing of the instant writ petition.
Till the date of filing.
At this stage, it may not be out of place to mention that Mr. S. Sharma, the learned counsel appearing on behalf of the petitioner, submitted that the said counterclaim was also withdrawn with liberty.
Yes. During the pendency after. Without any liberty. Without
Was
any liberty.
withdrawn without any liberty.
Without any liberty.
It is the further case of the petitioner that on the basis of the oral partition, the petitioner got his name mutated in the revenue records over his share on 23/8/2021. Subsequent thereto, the petitioner also obtained a planning permit on 27/9/2021 under the provisions of Section 5 of the Gauhati Building Construction and Regulation Bylaws 2014, read with Section 4 of the Gauhati Building Construction Regulation Act 2010. On the basis of the said no objection certificate so granted, it is the case of the petitioner that the petitioner completed 90% of the construction. It is the further case of the petitioner that in the meantime, the respondent number 8, having been unsuccessful in the suit and withdrawn the same, approached both the GMC and the GMDA authorities further to that. The respondent number 8 also took steps before the circle officer, Gauhati Revenue Circle, wherein the mutation so granted to the petitioner was cancelled. The resultant effect of the cancellation of the mutation are the impugned orders, whereby the respondent number 7, by the order dated 5/8/2024, cancelled have passed an order whereby the appeal filed by the petitioner was rejected on the ground that the mutation has been cancelled. The Chief Executive Officer of the Gauhati Metropolitan Development Authority had also revoke the planning permit on the ground that the petitioner is no longer the owner of the land of dag number 1110 or patta number 1, as the mutation was cancelled. The Commissioner GMC have also passed an order on 7/12/2024, whereby a direction was issued to pull down the entire unauthorized construction on the ground that the planning permit on the basis of which the petitioner raised the construction was cancelled, and thereby the entire construction was categorized as an unauthorized construction of the RCC building. It is under such circumstances the present writ petition has been filed. This court had issued notice. This court on 5/12/2025 on 20/12/2024 issued notice and further state the impugned notice dated 7/12/2024 issued by the Commissioner GMC. The respondents have appeared before this court. And it is the case of the respondents that as the mutation of the in respect to the land in question has been cancelled, the very planning permits so granted to the petitioner, being on the basis of the mutation order, is also liable to be cancelled and accordingly cancelled. Mr. Arde, the learned counsel who appears on behalf of the respondent number 8, submitted that after the withdrawal of the instant writ petition, withdrawal of the suit being title suit number so-and-so, 258/2000, 297/2022, a fresh suit has been filed.
Not filed. No suit is pending.
There is no suit, there has been no further suits filed. That is what was informed in the first half. There is no suit filed. The materials on this court have given its anxious consideration on the materials on record, as well as the impugned orders so passed. The fact that the petitioner is the son of late Mahmouda Begum is not in dispute. The fact that the respondent number 8 was sold a plot of land at measuring 11 lechas out of 1 katha 10 lechas of dag number 100.
1 katha 9 less. 9, it is wrongly.
1 katha 9 lecha is the actual area in possession, but your land is 1 katha.
3.89 R. 3.89 R. It is in paragraph. Sorry,
Out of 1 katha 9 lecha.
9 lessons. Because in title suit also they have stated here.
of Dag number 1110 of Patta number 1 of village South Sarania, Gauhati, is also not in dispute.
Number one.
It is a settled principle of law that mutation does not confer any title nor extinguish a title. The fact that the petitioner was issued a planning permit is also not in dispute. It therefore appears that there is a inter se dispute between the plaintiff petitioner and the respondent number 8, which is purely a civil dispute. And the question therefore arises as to whether the respondent authorities ought to have interfered in this private civil in the private dispute between the petitioner and the respondent number 8 and exercise its jurisdiction. It is not the case of the respondent authorities, as would be seen from the impugned orders, that there is any violation to any of the building bylaws or the approved plan. The reason for rejection, for dismissal of the appeal filed by the petitioner by the order dated 5/8/2024 by the respondent number 7, the order dated 19/11/2024 by the respondent number 3, as well as the impugned order dated 7/12/2024 by the respondent number 5, are all based upon cancellation of the mutation order. It is the opinion of this court that the impugned orders which have been assailed in the instant proceedings cannot sustain the scrutiny of law, and accordingly required to be interfered with. And accordingly, the writ petition stands disposed of with the following observations and directions. The impugned orders dated 5/8/2024 passed by the respondent number, passed by the member mayor in council (appeal) Gauhati Municipal Corporation, is set aside and quashed. Number 2, the impugned order dated 19/11/2024 issued by the Chief Executive Officer GMDA, that is the respondent number 3, is set aside and quashed. The impugned order dated 7/12/2024 issued by the Commissioner Gauhati Municipal Corporation is set aside and quashed. Number 4, the dispute between the petitioner as well as the respondent number 8 being a private dispute and within being a dispute of civil nature, the parties, the observations so made in the instant proceedings, observations and findings so given in the observations made and the findings given in the instant proceedings shall not prejudice either the petitioner or the respondent number 8 in any civil proceedings initiated. This court further observes that the impugned orders have been set aside on the ground of complete non-application of mine. However, it shall be open to the respondent authorities. However, the setting aside of the impugned orders shall not affect the rights and shall not divest the power of the respondent authorities to take action in the circumstance there is any violations to the building bylaws. What has happened? Anything?
Nothing.
Find out a way. This matter cannot keep on coming before me.
One payment has now been made.
It has not been made till date. I just checked. I have my account.
Do something. Why should this?
57,000 पूछना है आना है किसी दूसरे डायरेक्टर ऑफ मेडिकल
Replying with the director, that will be paid. Or she will kindly say this one.
No, I'm not looking into it. Taking into account why, you see, there is an order passed 2024. Matter is going on, you have paid some amount. Why you are not making it regularized?
That part, my lord, yes, I have talked with them, my lord.
Huh?
But they're facing some difficulty because, my lord, like a regular salary, my lord, that it cannot be paid, my lord. Like a regular employee, my lord, every month that amount will be, my lord, deposited in the account of the petitioner.
So should we, if that be so, should we
So that's why
put every year a compensation amount? Put it on affidavit that as a regular salary, it is very difficult to comply. So we pass it every year, one year in advance.
Quarterly.
1 year in advance. See, the thing is like this. Why this is being done? This is a child. After she must have now become 18.
Not yet. Not yet. She's
When?
about 14 now. About 14 years.
No, 14 was she
Yes,
in the year 2024. Now she'll be around 2016, 17. From 18, she will have her own bank account.
Well,
Yes.
10. 2016. 16.
So therefore, now something needs to be done from your side
My lord.
to regularize. Put it in some form of year. We have fixed the amount. Every year or every 5 years, there will be a change in the minimum wages.
Yes. That will have to.
The minimum wages changes only after 5 years. Why you are not putting a particular amount so that it is being disbursed?
Budgetary, my learned friend was saying a short while back, we were discussing how to solve it, your lordships. And my learned friend was saying that since it is not a part of the budgetary provisions, perhaps if they could make that a part of a budgetary
Regular,
provision,
my lord, provision.
regular provision as in the budget, then perhaps the problems can be sorted out. Because your lordship, what he's saying, 67,000 is for the period January 25 to May 25.
My lord.
We are in March 26, your lordships. They have not even released for January to, and what he has been, what my the client, I just tried to find out, and he went to the office of the Joint Director of Health Services in Mangoldoi. The Director of Health Services informed him that 67,000 will come to you after today.
Yes.
They wanted to see what is happening today, and only then they would release the 67,000. And has also told him reliably that yes, the rest of the amount for next year, I mean the pending, which would be from June 2025 till date, which my learned friend says it's an amount of approximately 1,21,000. That would perhaps
That
be released
proposal has been
only
voted.
after the elections. But he has been told that wo elections se pehle nahi milne wala.
What order should I pass?
Lord, we will give us some time, my lord, we'll sort it out, my lord, whether it can be paid
Should I
quarterly
pass the
or.
direction? No, should
I
I
will
pass
take
the
it.
direction? Direction to pay this 67.
Oh, yes, let it, such direction will be there in today's order. At least that will be released, but
So
balance
therefore,
amount, let the
you
government work
require
out
a
how it is to
direction
be
from
paid.
me for releasing.
No, not necessarily, my lord. In fact, it is already, it goes with the joint director, it will be released.
So I'll take
Probably
it as
the-
an undertaking by you that it will be released.
Yes, my lord, that will be
Within,
released. My lord, within say 1 week, my lord. One.
Mr. B. Gogoi, the learned additional advocate general, as well as the standing counsel of the Health and Family Welfare Department, submits that for the period from January 2005 to May 2005, an amount of rupees 67,502.50. The financial sanction proposal have been granted, and the said amount would be released in a week's time.
Well,
He further submitted that for the period from June 2025 till February
February
2026,
yes. There are-
further steps are being taken.
Sing the.
Proposal has been submitted to.
No, no, so further steps have been, I'm making it here, further steps have been taken. First, taking into account the above, this court deems the same to be an undertaking that the amount of rupees 67 deems the submissions so made by Mr. B. Gogoi, the learned additional advocate general, as an undertaking that the amount of rupees 67,502.50 would be released within a week's time from today to the petitioner's father. This court further directs the respondent authorities to take effective steps for due compliance to the judgment dated 22/12/2023 in WPC number 320/2014, and thereby ensure that the remaining amounts are being paid. That is being paid as per the directions passed.
Lordship, not petitioner's father, the petitioner. Not petitioner's father, petitioner, your lordships. It was not
Payment is
the
paid
writ
to the
petition,
petitioner's father.
lordship, because it is going to his account. That is why I just wanted to clarify.
Huh?
The amount is going into the account of the petitioner,
petitioner.
not the
Okay,
petitioner's
to the
petitioner. Deeply obliged.
Liberty given to the petitioner, counsel for the petitioner to mention the matter if within the period of in the second week of May, third week of May 2026 for listing the matter.
Deeply
I think to obtain some instruction and file affidavit, but I already been communicated on 24th. My lord, they say that the record is not traceable, my lord, they could not supply any, my lord, that document, my lord, instruction. Lord. Then it's, my lord, they asked me to pay for the some more time. Lord.
So you are not aware when the possession was taken? Why not?
Similar, they want some time because the record is of 2001. At that time, BTC was not created. 2003, it was constructed. Now they want some time for collecting this.
For what purpose the land was taken?
Record was not.
For what purpose the land was taken?
For construction of the embankment.
So the water resource.
Water resource. My lord, kindly see the last order, 11024, my lord. There is an observation. 11024, my lord, paragraph 4 of the order.
Yes.
11024, paragraph 4, next page, my lord.
Then award passed.
Regarding award, there are 4-5 orders were passed to show award, my lord. This honorable court wanted to see the award.
Yes, water resource department. At that time, BTC was not there. Did you make this land or not? You do one thing, BTC, you just find out he had a land. Find out where the land is and return it back to him. You return the land back to him. We'll take it as a requisition, not an acquisition. Return the land back to him.
They are trying to.
And if there is an embankment out there, he will demolish it. He'll demolish the embankment, no problem.
Also without
No,
getting the records, lordship.
not necessary. You do one thing. I pass your direction. You are the revenue authority. You just check it out where his land is. I'll ask him to go to your place and both of you go and look out there, the revenue authority, where the land is. Find out, then hand over the possession.
But already they have taken the money at that time.
Money not taken.
Yes, lordship.
How much?
They are
26 lakhs, my lord.
praying for enhanced amount. Lordship,
No, no.
they are praying for.
Now, my lord, the matter comes to, my lord, interest issue, interest factor, my lord. Interest factor.
You paid the money when?
In the year, my lord, 2014, my lord.
2014 you have paid.
Paid.
You have not paid the full
Because
amount.
they want a present valuation money, lordship.
No, I'm not. I'm not going to give them that also. I'm only giving them interest at
Interest.
15%.
Yes, my lord.
From 2001 to 2014. 26 lakhs into 15% per month, per year, into 14 years.
Lordship, without having any records, the PTC authority, they are trying to find out the records of this petitioner's land.
Why did you pay that amount into the year 2015? Why did you pay? You don't have record, but why did you pay?
As per this LAK's order.
LAK's order.
Yes,
So LAK's order was passed in the year 2001.
yes, lordship.
Why did you pay in 2015? So LAK's order is there.
Yes, lordship.
So therefore, when did you take the possession? That is the only question I am asking.
Yes, lordship.
It is not for you to compute. I'll pass the order. The day you have, because the possession, the right for his interest will only accrue from the day the possession is taken. So therefore, when did you take the possession? Till then, he is entitled to interest. 34.
That has to be, that has to be,
Okay, he will do one thing. He will pay back the 26 lakhs. You give him that land. Okay. Pay him the 26 lakhs and get back the land. As well as the embankment. Land means anything attached to the earth. So you take the embankment also. Okay. He'll pay 26 lakhs. You give him back the land.
at this position, lordship, the
What?
lordship, for that, we have to take instruction, lordship, whether the
Why
land is there or
That is
not.
why the matter was fixed on 23/2. Today is 23. Well, I gave you 20 days. Is the war in Iran or Israel affecting you to get this instruction? Well, Friday, get your instructions. Not how you. Else you will construe that till that date you did not pay, the possession was taken on that date. Therefore, this court, by an order dated 23/2/2026, has sought for instructions from the respondent authorities as to when the possession was taken, taking into account that the order of acquisition was made in the year 2001, and payment was made in the month of May 2015. However, no instructions have been placed before this court, taking a plea that that the respondents authorities are not in possession of any documents. The said stand taken by the respondent authorities do not inspire the confidence of this court. Rather, it appears to be a very lame excuse. Considering the above, list this matter again on 6th of April 2026. A final opportunity is being granted to file the affidavits as directed by the order dated 23/2/2026. Failure to do so, it shall be presumed that on the date in the year 2001, the possession of the land was taken and the payment was made in the month of May 2015. And accordingly, the interest under Section 34 of the Land Acquisition Act 1884-94 shall be computed.
May I pray for keeping part heard, madam?
Why?
Lordship has heard the matter at length.
Not necessarily. What is this? Again the matter is coming back to me.
My bad luck.
They dismiss.
No, Lordship,
Your bad luck is bad luck. Can't help you with luck. The luck can't be so bad that it is here before me from 13 to 2026, 25 to 2026. Today also it is done. Now what is your case? Let me dismiss your case.
Lordship, the respondents erected 400 kV power line, Lordship, over the land of the petitioners. All are agriculturist and they have the patta land, Lordship. Without any proper assessment, they have erected, threatening some petitioner also, some case also filed against
When was the land, when was the erection done?
It started from 2009, but still some of the place.
2009.
Yes.
Okay. When did you receive the compensation?
We have not received, Lordship. Only some, here is, I have find out from the affidavit, Lordship, only some of the petitioners, they have received the jirat, some of the jirat amount. Most of the petitioners, they have not received. My case is that, Lordship, proper assessment should be made as per Telegram Act, Lordship. And in the meantime, Lordship, one central government notification is there.
Who has not received the compensation? Yes, who have not been paid the compensation?
According to our, we have in paragraph 5 and 6, we have said that they have, the assessment was made in their presence, my lord. And the compensation has already been paid to them, but they have also received the amount compensation without taking any protest, my lord. In paragraph 5 and 6 of our affidavit, we have stated, my lord. If they are agreed as to the assessment made by towards the compensation amount, my lord, they could have approached the competent authority there by availing their statutory provisions, my lord, as laid down under section 16(3) of the Telegraph Act, my lord.
When did you raise the dispute?
I have filed representation 2019, Lord.
Why? Your possession was taken in the year 2009.
No, complete possession is not taken 2009, Lord.
Possession, let us see where. Where is your annexure?
Representation I have filed.
Huh? Where?
Lordship, I
7E.
have stated in paragraph 11, Lordship, of the writ petition.
No. In inviting here, we undersigned would like to inform you that they had acquired land of the undersigned for construction of the voltage without serving any proper previous notice and without paying any compensation to them. It is also stated here that no damage assessment has been carried out by the Power Grid India or the local buyer for land compensation. Therefore, we pray that your honor is so and so.
Lordship, my case is, Lordship, more than 1,000 petitioner earlier approached before this honorable court, Lordship. We are the same category of the person and same transmit line, Lordship. The similar order, I have annexed 3 order, not only 3 order, Lordship, almost 6-7 cases, similar order passed, Lordship. The assessment to be done as per the Telegram Act and the present notification should be applicable, Lordship. The notification is apply in every case, Lordship. Because there is no policy decision before 2015, Lordship.
These are cases where in 2014 to 16, these people were done and the petitions filed in 2019.
Yes, my lord.
Okay.
Yes.
But here is a case when it was done in 2009.
Started from 9, Lordship, but
When did
process
it
is
finish?
going on, Lordship. Still some places there is no connection, Lordship.
When did it finish? Where have you mentioned? Let us see. Your representation is also vague. Come up with
Lordship, kindly see the notification, Lordship, one moment.
We don't know whether you're, how do you say that you are the owners of the land? Why should we pass? Huh? Where is the document that you are the owner of the land?
I have just stated, Lordship. Stated in my paragraph. Lordship.
Where? Which paragraph? To me? Dismiss with cost, na? 1,000 rupees per person of one writ petition. 112 and another 1,12,000. Isn't it, Mr. Das? 1,12,000. Where is it? Where is it that your land has been taken? Where?
Is not paragraph 2, Lordship.
Paragraph 2, what does it say? Where?
The documents I have not annexed, Lordship.
Nothing is there.
I have not annexed.
Sorry, I can't help you out. I'll appeal against. The courts may help you out. Level.
Lordship,
Another
then,
one, same. Heard, Mr.
Lordship, there is another order is there,
Not
Lordship.
necessary.
One-
A.U. Ahmed, the learned counsel appearing on behalf of the petitioner. Mr. N.C. Das, the learned senior counsel, represents the Power Grid Corporation. Mr. N.C. Das, the learned senior counsel, assisted by A. Das, appears on behalf of the Power Grid Corporation. Ms. M. Borman appears for the respondent numbers 5, 6, and 7. Appears for the state of Assam as well as the district administration. The grievance of the petitioners in both the petitions are that the respondent Power Grid Corporation of India had been undertaking erection of high voltage transmission line from Balipara to Bongaigaon since 2009 onwards. And they belong to some 40, and these petitioners belong to some 41 villages. And they claim to be affected. But nothing has been mentioned as to how the petitioner claimed to be affected or whether in their plot of land any erection was carried out. It is the case of the petitioners that in case of payment of compensation for Jirat, the Power Grid Corporation has paid some of the person's compensation of Jirat of only 23 to 25 meters of right of way area in 400 kV DC Balipara Bongaigaon transmission line. But it is the case of the petitioner that the said amount should have been much more. It is the further case of the petitioners, as would be seen from paragraph number 9. That the respondent, Power Grid Corporation of India, had denied the petitioners the rate fixed by the competent authority and has paid rates much lower than what has been paid. Line of WPC number 1741/2020. Petitioners herein, therefore, have approached this court seeking certain similar directions as have been passed by the learned coordinate benches. This court have duly perused the orders passed by the learned coordinate benches and have also perused the materials placed before this court in the present two proceedings. There is no mention in the instant writ petition as to how the petitioners have been affected, where the land of the petitioners are situated, or as to any any power transmission lines have been laid over the lands of the petitioners. There's also no mention that it is also seen that though the petitioners admit that they have received the compensation, they have not mentioned when such compensations have been received. It is a trite principle of law. Section 16(1)(d). Section 16(3) of the Indian Telegraph Act 1885 permits a person who is aggrieved by the insufficiency of the compensation to approach the learned district judge, within whose jurisdiction the property is situated, and be determined by him. The petitioners have not approached the respondent have approached the district judge, within whose jurisdiction the lands of the petitioners are situated. This court finds it very pertinent to take note of the judgment of the Supreme Court in the case of Kerala State Electricity Board versus TP Unhali Umma, reported in 1976 4 SCC 634, wherein the Supreme Court categorically held that an application to be filed before the district judge in terms with section 16(3) of the Indian Telegraph Act 1885, the provisions of section article 137 of the third schedule to the Limitation Act of the third schedule to the Limitation Act 1963 would apply. Taking into account the above, as the instant writ petition is completely vague when the petitioners have received the compensation, it would not be in the interest of justice to permit the petitioners to approach this court by way of a writ petition for redetermination of the compensation, so that a further avenue is opened. this court also takes note of the affidavit in opposition filed by the Power Grid Corporation, wherein it is being mentioned that the entire mention that the assessment of the right-of-way corridor of 46 meters width have been considered and zero compensation have been paid. Against actual damage to trees, crops, etc. Considering the above, it is therefore the opinion of this court that these two writ petitions in addition to that, it is seen that the payments were made in the year 2014 and the petitioner has approached this court 7 years thereafter. Under such circumstances, it is the opinion of this court that the instant writ petitions lacks merit
Lordship,
and accordingly both stands dismissed.
Lordship, all petitioners are not received. I have stated, Lordship. All petitioners are not received, Lordship.
Not received. Very good.
Some of the petitioners.
Therefore, I refer to paragraph number 9. We said all the petitioners have received. See paragraph number 9.
In paragraph 2, I have stated.
2, no 2, 3. When you are copying and pasting petitions from others, you have to be careful, Mr. Counsel.
In this case, my lords, I have received instruction. That I do. I'll may kindly peruse serial number 10 and 13, lordship. Paragraph 10 and 13, lordship. Here he is claiming Doboka, and whereas he was not participated in the.
Make the impugn order. What is this document then? Annexure 11?
Actually, there is a notice issued by the authority, my lord, to and to pay, my lord, yes.
This is in respect of lordship another writ petition. This lordship 162624, lordship.
No, this document says that you have not deposited.
Lordship.
In this NIT was issued. I submitted tender, my lord, for a particular fishery, and my lord, then there is no settlement, my lord, no handover of the fishery, my lord, period expired. Then they issued a notice. Yes, you deposit you submit the area installment.
Then, my lord, I filed a petition with honorable court. Sorry, my lord. And the honorable court, my lord, remanded back the matter to file a representation. I filed the same. Then my lord, they have issued the order. Yes, you pay the area amount. There is no settlement, my lord. No handover of the fishery. Nothing. But how then, my lord, I am to deposit. My lord, matter is done when I deposited some amount, my lord, 2 installments with them, my lord. As per
You
the,
submitted in respect to which?
this is, my lord, there are 2 fisheries, my lord, small fisheries. One is, my lord, number 100, Doboga fishery. And another is, my lord, Jamuna. There are 2 fisheries. And here in the question, your lordship, they are issued, my lord, 2 joint orders. Yes.
What is this order you have enclosed, page 29 and 30? Is not clear.
29, 30 is lordship.
Page 29, my lord, that is 28. 29 is the order passed by the Honorable Court, my lord, directing me, lord, to submit a representation.
Read the entire order.
Para, my lord, page 30, 11 portion. May, my lord.
30 is the writ petition is accordingly disposed of.
On consideration, the submission made by the councils of the for the parties, the petitioner is given liberty.
We don't have that page.
My lord. Page 30, my lord.
We don't have that page.
Is it? Yes.
So I may put it by way of affidavit lordship. Paragraph 9 also says that he used unauthorized. Paragraph 9 of our instruction also was. Paragraph 9 of our instruction also was.
We have not taken possession of the fishery. We have not collected also revenue also, my lord. Nothing.
To file an affidavit.
So I'll put it by way of affidavit.
The Igowedalon, the additional senior government advocate, submits that he has received the instructions and he will be filing the same. And what is this stay business?
Stay, my lord, the order by which, my lord, they directed me, my lord, to deposit the amount, that is state, my lord. Last annexure, my lord. Annexure 11. Yes.
What is there to stay this?
Lord. And the same page, my lord, 33, annexure 11. That is state. You are informed to deposit the area installments within 10 days. That is state.
Area of what?
I don't know, my lord. They are saying installments, but I have not taken position. I have not given order. I have not given up to the order.
Paragraph, if you go by the paragraph 9 lordship, and it says that they are without any authority lordship, they are running the fishery. Lordship. That's why that part was given. Lordship.
What is the order? Give me the order. Without fishery order, how I can, my lord, government fishery? This is 100% fishery. How can I enjoy the
It's
same?
not 100%, it's 40%.
40%. Yeah, 40%. Maybe.
So you mean to say that he was given for a particular period to 31/3/2024. At that point of time, he had deposited certain amount. Now he says that possession was not delivered to me, so return me back that money. Didn't it? And he therefore submitted a representation sometime in the year 2022. Now you pass an order in the year 2023. Look here, what we have done is nothing to that effect. You have run it this, you have paid that is finished. Now, but you were unauthorized running this and now you deposit this amount. How can you, that order is also wrong.
Yes, I put it by way of affidavit lordship.
But my submission, lordship, is there.
We can set aside this, but not to refund that. What do you want?
My lord, NIT was issued, but they have
Not
not.
to refund that.
NIT is not.
Set aside this. What do you want?
Maybe, my lord, I say long back, amount is very low, I've seen.
So we can set aside this because unless they have given you the authority, You cannot give a post facto.
Even order was not issued.
So that order has
From,
to go.
from office, my lord, from office, they have not any
So
issued
we
any
set
order.
aside that. But the question of refunding does not arise. We need to
And-
close. Hardly a
they-
type of, how many petitions are going to file for this 4,900? Huh? This is the second round of litigation.
round of the-
4,900.
And also, my lord, called visit was, my lord, about, my lord, yes, called visit.
Even earlier round was also lordship.
4,900.
There is a minute called visit, amount to be able.
Mr. Rashid, we need to bring to a closure.
I'm a landest.
Heard Mr. A. Rashid, because I'm setting aside this, because otherwise later on, it will be shown as areas and you cannot participate. So we set aside this.
Yes, that's it.
We can participate in the.
Heard Mr. A. Rashid, the learned counsel appearing on behalf of the petitioner. And Mr. A. Gogoi, the learned additional senior government advocate appearing on behalf of the respondent numbers 1, 2, and 3. The petitioner has approached this court seeking refund of the call deposit of rupees 6,000 paid with tender and 2 installments at the rate of 4,900 deposited on 21/2/2019 and 21/2/2019, and also to quash the notice dated 23/12/2024. This court duly takes note of that this is the second round of litigation. On an earlier round of litigation filed by the petitioner seeking the similar reliefs, this court had disposed of the said writ petition by an order dated dispose of the writ petition being WPC number 1650/2024 by an order dated 25/10/2024 for the respondents to duly consider the same. In pursuance thereto, a hearing was conducted on 5/12/2024, on 7/12/2024, and pursuant thereto, the order was passed on 23/12/2024, wherein it is mentioned that the petitioner had deposited rupees 4,900 and 3,250 for the 100 Doboka Min Mahal, and the term of the fishery expired on 31/10/2024. It is further mentioned, apart from that, the Additional District Commissioner Hojai had directed the petitioner to deposit a further amount as area of installment within 10 days without specifying as to what is the area amount. Pursuant to the filing of the instant writ petition on this court by an order dated 29/1/2025, issued notice and state that communication date order dated 23/12/2024. Today, Mr. K. Gogoi has placed before this court a set of instructions which are collectively kept on record and marked with the letter X. From a perusal of the said instructions, it is mentioned that the 100 number Doboka Min Mahal the petitioner was running without any extension. And as such, the petitioner was liable to pay certain amounts. Court inquired with the learned counsel appearing on behalf of the respondents as to if there was no extension granted to the petitioner. How is the question of payment of any areas by the petitioner? The learned counsel, with all fairness, submitted that without a grant of an extension, the question of post facto asking for payment of certain certain amount would not arise. So considering the said submission, this court is of the opinion that the impugn notice dated 23/12/2000, impugn order dated 23/12/2024, insofar as demanding the petitioner to pay certain areas is required to be interfered with. This court, however, is also of the opinion that the petitioner is not entitled for the refund of the amounts as have been claimed in the instant writ petition. Accordingly, the instant writ petition stands disposed of with the following observations and directions, comma. The petitioner herein is not entitled to the refund of the amount of the call deposit of rupees 6,000 paid with the tender and 2 installments at the rate of rupees 4,900 deposited on 21/2/2019 and 21/2/2019 as has been claimed in the instant writ petition. Number 2, this court sets aside the order dated 23/12/2024, whereby only to the extent whereby there is a demand being made for payment of certain areas. Scoring writ petitions.
Next item also same lordship, only fishery is, it is a Jamuna fishery lordship. Here I have not received instruction, otherwise everything is same lordship.
Same.
The same order will do lordship. Only fisheries name may be changed, Jamuna fishery lordship.
It is 17 Jamuna fishery.
That is the other one, na?
And
17 Jamuna.
lordship, amount also same lordship.
Amount same, also call deposit will
There is the other person.
Other person, other
Yes.
person.
other one and
Munna,
call deposit
what is his name?
It is Abdul Salam.
Abdul Salam.
Abdul Salam is this. The other one is different.
Abdul Manna Valley.
Wonderful,
Manna.
wonderful, wonderful.
Okay, you say KK.
Oblaji lordship.
But demarcation is going on.
Lordship, not, they have not done any demarcation, Lordship, actually.
No, I am asking her.
Yes, your lordship.
Demarcation?
Going on, complete going on. Yes, sir. Lordship, we received an affidavit. I don't know whether it's on record or not. Lordship had directed council to file an affidavit indicating whether his land, location of his land and the boundary of his villages. They filed an affidavit.
When?
Today, Lordship.
We received it today at 7 in the morning.
You filed your affidavit. You filed your affidavit.
Lordship,
What is
today,
that?
today morning, Lordship.
You have a look at that affidavit.
Yes, Lordship.
And if you have anything, you submit your reply. If you
Yes,
have,
Lordship.
we'll have it on some other thing.
Yes, Lordship.
In pursuance to Econ Petition, 467. In pursuance to the order dated 18/2/2026, Mr. R.M. Das, the Learned Standing Counsel of the Dimahasa Autonomous Council, submitted that the affidavit as directed has been filed. However, filed today. However, the said affidavit is not on record. This matter again on 1st of April 2026. Liberty given to the petitioner to file any reply thereagainst on or before 30/30. You have to file your reply by 30.
Yes, Lordship.
30. The registry shall bring on record the said affidavit. And the other one is Ms. G. Goswami, the Learned Counsel appearing on behalf of the writ petitioner, submits that the demarcation proceedings are still going on. So taking into account this matter again on 1st of April 2026.
Compliance.
You file affidavit.
Yes, my lord, I file a return.
What is your affidavit?
My lord, paragraph 6, 7, my lord. Yes,
You are saying because it's a kata,
yes, my lord.
HUF.
Yes, my lord.
Your case must be there.
Yes.
And HUF is not entitled after that year.
Yes, my lord. The gazette notification is there. Next, A, my lord, page 41.
What is this? I don't understand. Only come to paragraph 7.
Perhaps of my affidavit. Lord, so
We deposited 3 lakhs,
30,000. 30,000.
30,000. Interest is 1,11,827. Total is so and so, minus TDS is so and so, and you paid 1,27,000. Now, what is the petition asking?
It is asking, my lord, is subsequently it was updated, my lord, of 2010, my lord. This passbook was updated after 2010, my lord. So that amount, my lord, the updated amount they have claimed, my lord. This is the case.
But it was discontinued for in
From 2000, my lord, 2005, my lord.
1992.
Yes. Yes, my lord. Entitled interest until on 31st December 2005, my lord.
Interest is only paid till 31/12/2005.
Yes.
Why?
Because it, as per this, my lord, gazette
There is a gazetted notification.
Yes,
Where is that notification?
page 40, my lord, next A, my lord. My lord, 2 Roman 2, my lord, A, my lord.
Why didn't you return him the money?
Not, he is not asking, my lord, he has not asked, my lord, because, my lord,
But can you see the outstanding balance in an account other than an individual account shall be refunded to the depositor on a date not later than so and so.
yes, my lord.
So when that is the rule,
No, they have to approach, my lord, accordingly, when they approached, my lord, it was, my lord.
in an account other than a year shall not earn interest after 31st of December. Mr.
Till 2010, my lord. Till 2010, they have regularly crediting the interest in my passbook, my lord.
But that is immaterial.
Now,
Somebody doing out there, this is against the law.
my lord. But my second thing is that as per notification, my lord, they were supposed to refund by themselves only, my lord. It says, my lord, notification says, shall be refunded, my lord.
Understood.
And it was not the petitioner, my lord.
Understood.
My lord.
But see 510.
My lord.
Notwithstanding anything contained in this rule means everything goes.
Yes, my lord.
Then
one thing is that, my lord, they have called my money till 2024, my lord.
Understood.
They have
But
utilized it, my lord.
But when it is given in the notification published in the Gazette, you
My lord.
should be deemed to know. If you
Definitely.
don't know the law, then I can't help it.
It is to my, but it's
If it was not published, it would have been a different thing.
my lord. It
Can't
was
help it.
because what happened, my lord, since they have been regularly crediting the interest in the passbook, it was under impression that the scheme is going on, my lord. It was a
Understood.
difficulty, my lord.
Understood. That officer must be mistake. He also may not have known about this.
But only
I can help you because of this. In Rule 6, after Rule 9, the following shall be substituted, notwithstanding anything so and so. not doing anything. So there cannot be a rule. Heard Mr. R.S. Mishra, the council appearing on behalf, because you see, he has not brought in this one. He has brought in this rules notification, but there is another notification by which it has been mentioned that portion he has not brought in. There is a mention wherein I think this has happened in 2005 also. The act is amended, whereby it says that it is only an individual who can open that account. It cannot be opened in the name of a HUM. I thought that he was bringing that document before me. Heard Mr. R.S. Mishra, the learned counsel, appearing on behalf of the petitioner. Mr. S.K. Medi appears on behalf of the respondents. The petitioner herein, which is an HUF, is aggrieved by the actions on the part of the respondents in not paying any interest on the deposit made by the petitioner till 16/12/2024 from the date of opening of the account. The materials on record show that the petitioner, which is an HUF, opened an account with the respondent number 5 bearing account number 0057421285 bracket old account number 230018.
It was a fund, account was before respondent 6 minutes. Account was opened before respondent 6 minutes.
He is saying 5. What do I do?
If in my reply minute. it's-
Before the respondent number 6. Before the respondent number 6, bearing account number so and so with one-time deposit of rupees 30,000. The said account was opened under the National Savings Scheme 1987. And the petitioner was issued a passbook. The said passbook was updated till September 2010 with a balance of rupees 1,92,768. And thereupon the passbook could not be updated. On 22/12/2023, the petitioner submitted a letter before the respondent number 3 requesting for updating the KYC as well as the passbook. After the submission of the aforesaid letter, only the KYC of the petitioner was updated. However, it is alleged that the authorities did not update the passbook nor apprise the maturity amount to the petitioner. Under such circumstances, the petitioner on 30/1/2024 submitted a letter wherein the petitioner submitted the following documents for closure of the accounts, submitted various documents for closing the account. In pursuance thereto, the respondent number 5, office of the respondent number 6, handed over a check bearing number 084112 dated 16/12/2024, issued by the respondent number 6 or 5?
5.
Respondent number 5 for rupees 1,27,644 towards maturity of the National Savings Scheme account bearing number 0057421285. The petitioner is aggrieved. The petitioner submitted representation before the respondent number 3 and 6. Being aggrieved by the non-disbursement of the amount to which the petitioner claims to be entitled. The said representation, however, pursuant to the said representations, the petitioner also followed it up with a legal notice dated 11/2/2025. And it is under such circumstances a reply was received on 24/12/2024. How is it legal notice is 11/2/2025? Respondent force letter is 24/12/2024. How is
There
it?
may be some mistake of date because it was received subsequently, my lord. It was received subsequently, my lord.
Okay, to had submitted a legal notice. In the meantime, the petitioner had received a letter dated 24/12/2024, wherein it was informed that the petitioner was not entitled to interest after 31/12/2005. And accordingly, the said amount of rupees 1,27,644 was paid by deducting the tax to the tune of rupees 14,183. It is under such circumstances the petitioner, being aggrieved, has approached this court by filing the writ petition. This court have issued notice on 6/6/2025. In pursuance thereto, an affidavit has been filed by the respondents on 6/3/2026. In the said affidavit so filed, the respondents have stated in detail why the amount to which the petitioner was entitled to was rupees 1,27,644 and not what the petitioner has claimed. Paragraph 7 of the said affidavit, being relevant, is reproduced herein under page 35. This court further finds it relevant to take note of Annexure A to the affidavit in opposition so filed, wherein it is categorically mentioned that from where it can be discerned that the Post Office Saving Account Rules 1981 was amended by the central government in exercise of the powers under Section 15 of the Government Saving Banks Act 1873 by the notification dated and which was notified by the notification dated 27/7/2005. A sub-rule 10 to Rule 6 was inserted, whereby it was made clear that deposit in an account other than of an individual account shall not earn interest after 31/12/2005. Taking into account that the said aspect, and said aspect, and the justification given by the respondents as to why the petitioner was only entitled to rupees 1,27,644, as mentioned in paragraph number 7 of the affidavit in opposition, which is quoted here in above. It is the opinion of this court that the petitioner, being a Hindu undivided family, could not have been entitled to interest beyond 31/12/2005. Accordingly, this court does not find any ground for interfering in the writ petition. The writ petition accordingly stands dismissed.
May it please your lordship. Lordship, the issue here involved is relates to section 3H subsection 4 of the National Highways Law. And the petitioners and the respondent, private respondent number 7 to 13, they are the legal heirs of one late assessor, Borthakur Mela.
Payment received
Payment disbursed, your lordship.
to you.
Your lordship.
You got
Not
the
only
money?
to me, to other also, your lordship.
Who is the petitioner?
Petitioners are, my lord, the
Your lordship's affidavit in reply filed today. I received today.
no, my lord, I have filed the affidavit in reply in response against the affidavit in opposition filed by the private respondent. But here, my lord, the till date, my lord, the Kala has not filed any, my lord, affidavit, my lord. Because, my lord, that is very much necessary. As we are challenging the challenging the arbitrary and illegal action of Kala of disbursing the entire compensation amount in spite of there being dispute regarding apportionment of share. And one more interesting point is that, my lord, two plots of land belonging to the same parties, my lord, two plots of land were acquired for widening of this national highway. In regard to the other plot of land, my lord, as because there is a dispute regarding apportionment, my lord, it was referred to the court of the district judge, my lord. And I have enclosed their order also, my lord, here also, my lord. Then that has been pending before the district judge.
He has said that you have filed a reply.
Yes.
You have to give him that reply is not here. And what about Kala? You bring on record your affidavit.
One of the thing in this case, your lordships, the petitioner has suppressed everything. He already filed civil suit for compensation, and that was withdrawn by him with liberty to file a fresh. And now here in this writ petition, he said nothing, and he's saying that he has no knowledge that whether the amount was disbursed or not. So this is the suppression of tax.
That is not.
Entire thing suppressed. He has a knowledge regarding that. He filed suit, everything.
Well, on this, my lord, I have give my reply, ma'am.
Mr. Anja, the learned counsel appearing on behalf of the respondent number 7 to 13 submits that that he has received an affidavit in reply filed by the petitioner only today. This court also takes note of that the impugned action that the present petition has been filed assailing the actions on the part of the competent authority of land acquisition, which the HRMA appears for the same authority. So, list this matter again on 8th of April 2026. In the meantime, the respondent, the competent authority of land acquisition, is directed to bring on record its stand by filing the affidavit on or before 6th of April 2026.
May it please your lordship, my lord. My lord. Your lordship. My lord, here, my lord, I purchased the, my lord, land from the bank, my lord, on auction in 2014. They taken my money, my lord, and this money I, my lord, took from the bank on loan. I am paying interest. Now, my lord, keeping in view of that some proceeding was pending, that they did not, my lord, hand over possession. Now all proceedings are complete, my lord, by 2024. All proceedings are complete. There is no any proceeding pending. They also admitted in their affidavit. I am filing representation. They are not responding. I could not get them on a land, my lord. If they cannot give the land, my lord, with heavy interest, they should pay back my money, my lord.
With interest.
Heavy interest, my lord.
Lordship, early in the morning, I have requested that we will make a mention, but due to things I am not feeling well today itself. So I just pray for that it matter may be taken up on Monday or Tuesday. It's for the conveniency. But otherwise, the matter has been that since the third party interest has been created in the property which we have issued in sale certificate, that the borrower has created a third party interest in the property after issuance of the sale certificate, your lords.
That submission cannot be made.
Matter. How can he create a third party?
He has sold out, your lordship. He has sold out, and when we went to there for take over the property, then we have found now that so many people are sitting over there. We have made an application before the DC also for taking possession.
Under what provision?
Huh?
Under what provision did you sell it to him?
I have sold under Surface Act.
13 months.
Why you are not taking the help of the district magistrate?
Yes, your lordship, that has been taken because at the time when we have issued them the sale certificate, the property was totally blank. Your lordship, there was no possession of any person. Either of the borrower also has lying vacant possession.
No, Mr. Mr. Sharma, this type of lame excuse can't help you. You are concerned, you have the power to take it under that. If the central bank or the bank is interested, this is not being done. Now, if there are third party rights being created and all, then what is there? Then pay him the money if you are not in the position. from 2014.
14, my lord, yes.
14, 20, 12 years, 18% interest per month.
My lord, it is justified, my lord. Yes, I'm happy with that, my lord. Because I could not utilize the land
Yes.
that was my lord, purchased for medical.
You pay as per
establishing.
the interest which you are paying in the loan.
No, no.
Loan,
he
how
is
much
not
you
a
have?
borrower.
I am paying, my lord, yes, 13.94%, 13.25%.
There is no, your lordship.
No, you cannot. No.
Yes, yes, page 20,
If
my
you
lord.
are taking, if you are initiating a surface proceedings, you have to either give him the land and you have the
Yes.
law mandates it that you can very well take over the possession and give it to him.
And
You
that-
should have done it. If
And
you have
that is the
failed to
judgment, my
do
lord, in the
so,
Ferrous Alloys, my lord, by the Supreme Court, my lord.
please the matter of the secrets.
My lord,
When I am saying something
I'm
in your
sorry.
favor and you are trying to do
I'm
this,
sorry, extremely
this
sorry.
is the matter before any other bench accepts.
I'm extremely sorry, my lord. That may be taken back, my lord. My lord, we are learning, my lord. I'm sorry, extremely
Not
sorry, my lord.
necessary.
My lord,
This is
maybe
the matter
please-
before any other bench without me.
my lord, kindly forgive, my lord. So,
Sorry. I'm trying to help you out and you are trying to, you have to, let it be done before any other court.
my lord, next time I'll not do that, my sorry.
Next time in some other matter, this matter is gone. Yes, what is this?
Non-payment, lordship, as per last order, we were supposed to file an affidavit by the chief engineer. We have filed an affidavit, your lordship.
File the affidavit?
Yes, your lordship.
It has been submitted that the respondent PHE
Copy by sir.
has filed an affidavit. How much? Is he entitled to any amount?
He's entitled as
26
lakh 23,383, your lordship.
Ah.
As per the latest field verification done, your lordship.
Earlier executive engineer, my lord, same was
Now,
supported by the chief
pursuant to
engineer.
that, I have directed that.
Yes, yes.
affidavit to be
Additional affidavit we have filed. We served them a copy and the verification was carried out. In that verification, the amount comes to 26 lakhs 23,383 only.
You have the affidavit.
Same. Mane earlier,
One thing, you do one thing, take that money and
Madam,
fight the
that-
other matter for the purpose of
civil suit.
civil suit.
Yes, ma'am.
Better, na?
Yes.
Anybody has the affidavit? The petitioner heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Gogoi appears on behalf of the respondents.
All the respondent, lordship. PHE
The
department.
petitioner herein has filed the incident with petition claiming an amount of rupees 53,57,899. Pusto. It is the case of the petitioner that the petitioner had completed various works এইখিনি আপোনালোকে সেই আমাৰ নন পেমেন্ট অফ ডিউজৰ নিচিনাকে আপোনালোকে চাই তাৰপিছত it is seen that pursuant to a notice being issued by this court on 1/12/2000, pursuant to a notice issued, pursuant to an order passed by this court on 1/12/2025. No, pursuant to a notice issued by court on 25/7/2025. An affidavit has been filed by the respondent number 5. Stating inter alia that the petitioner is not entitled to the amount of rupees 53,57,899, but is only entitled to an amount of rupees 27,34,516, isn't it?
26 lakhs 23,383.
No. Okay, 26 lakhs 23,383. Taking into account that the very office of the executive engineer, that is the respondent number 5, had issued a liability certificate of rupees 53 lakhs 57,899 this court passed an order on 1/12/2025 directing the chief engineer PHE to file an affidavit explaining the said discrepancy. In pursuance thereto, an affidavit has been filed by the respondent number 2. Additional affidavit has been filed by the respondent number 2 on 7/1/2026. It is mentioned that pursuant to the order passed by this court, certain verifications were carried out, and it was found that the petitioner was only entitled to rupees 26,23,383. Full stop. Taking into account the above, it is therefore clear that the respondent authorities herein have duly admitted an amount of rupees 26,23,383. However, the remaining amount of rupees 27,34,516 have been completely denied. Accordingly, this court disposes of the instant writ petition with the following observations and directions. Taking into account that the respondents have duly admitted the amount of rupees 26,23,383, the respondent herein, authorities herein, and more particularly, the respondent number 1, 3, 1, 2, 3, and 5. 1, 2, and 3 are directed jointly and severely to take effective steps for releasing the said amount of rupees 26 lakhs to and so within a period of 5 months from the date a certified copy of the instant order is served upon the respondent number 3.
3 will do the lottery.
Additional chief engineer. Additional chief engineer 3, na?
It's 3 additional chief engineer.
Or should we have it the additional mission director?
Let it be the respond number 2, your lordship. Will come.
Respond number 2. To the respond number 2. To the chief engineer PHE, water, to the respond number 2. As regards the remaining amount of rupees 27 lakhs so and so, taking into account that the respondents have disputed the same, the petitioner would be at liberty to approach the competent court of civil jurisdiction claiming the said amount, if so permissible under law. For that purpose, this court observes that as the petitioner has been bona fidely litigating in the instant proceedings, the period from 27/6/2025 till date be excluded while computing the period of limitation. Oh, here we have the additional affidavit. Ajo ekini bharai dibo ha. What is this?
Ma'am's lordship. Must have taken another date, lordship. My service not available. In 27, our senior counsel also engaged in another court, lordship.
Respond number 7 is who? What are you challenging?
Lordship, page 53, lordship.
Page
53, lordship. In item number 26, lordship.
56.
53, lordship. 53.
Now what is this? AGM is what? You have challenged the AGM.
Yes, Lordship. Yes, AGM was held on 12/9/24, Lordship.
Hmm.
Without quorum, Lordship.
Without
Without quorum, Lordship. Without quorum, Lordship.
quorum,
Yes, Lordship.
without quorum.
Yes, Lordship. Kindly peruse the page number 19, Lordship. An inquiry report, Lordship.
Huh?
Page 19, Lordship.
Hmm.
It's an inquiry report, Lordship.
Yes. And what is the other institution?
Under Senior Counsel RP Sharma sir APR, Lordship. Under Senior Counsel RP Sharma sir APR, Lordship. Out of same allegation, Lordship.
What should I do? What is the IA for?
I already disposed of, Lordship.
Completement.
We made the
Who is response number 7? You are. You are response number 7. Okay. What is the present status of the society?
In fact, we have filed a affidavit. The AGM has been upheld by
Huh?
the register by the impugn order. My lord,
Why there are 2 writ petitions?
Lord, in fact, same shareholders challenging the same order, two different, my lord, different group, my lord.
Same.
Same.
Quorum.
Same impugn
same
order. Challenge,
But the register's order doesn't say about quorum.
yeah, does not say. They did not, my lord, press that point. Only my,
You are praising the point of quorum here. Because the register's order says about notice,
yes,
isn't it?
yes, correct.
but
That-
actually some non-members cast their vote, Lordship.
So do I look like a register? So how can you raise these the points out here for the first time? Is it permissible, Mr. Talukdar?
My lord,
Is it permissible to raise the quorum point for the first time here?
it's a, my lord, factual part, because quorum, my lord, facts
Quorum
are,
is a question which
yes.
needs to be looked.
It's not a
at
legal-
register.
Yes.
And if in a proceeding
yes,
where you have raised on the question of notice,
my lord,
first of all, if it is a question of notice being not issued properly,
yes,
did he participate?
yes.
Did you participate?
Yes, Lordship.
Then,
If you had participated, then there is no question of your notice being
Notice.
not affected.
yes,
You are not affected by that. Second, if it is a question of quorum being not there, then it is a very well cases you should have raised it there.
yes,
It is under 111.
111,
You did not raise that.
did not,
Have you raised that 111? Or what is this proceeding? This is a proceeding under section 40.
my lord, in fact,
This is for confirmation of the,
Yes,
for the
yes.
confirmation of the AGM.
in fact, my lord, the AGM has been confirmed by the ARCS. On appeal, my lord, no, it has been disapproved. On appeal, my lord, the AGM has been upheld, my lord,
By the register.
by the register.
Okay, now the question of quorum, he has not raised
No,
it.
no, the register has mentioned, my lord, in his order.
So
Only,
therefore,
confined
that,
to the-
that proceedings which were there
my lord,
is a proceedings pertaining to non-confirmation of the AGM.
my lord. Basically, my lord, the ARCS has required under 45 has disapproved. Because his approval is necessary. Disapproved. And against that, my lord, the register on appeal, my lord, has approved.
So therefore, it is a proceedings under that for a section 40 or whatever
My
means,
lord, my
for
lord.
approval, disapproval of.
Disapproval is.
But he has not filed an appeal under 111.
No.
No,
Why
Lordship.
you are not filing an appeal there and raising the question of quorum and coming here? My question is that, you see, that is the fact finding. I cannot go into the fact finding here, whether the quorum is there or not. How do I look into it? I'll ask them to produce the documents. Why should I? You have not raised it before the authority, before whom you can raise it.
Lordship, fix another plan.
What?
The Senior Counsel
Senior counsel?
RP
Who
Sharma
is
sir.
the senior counsel here?
RP Sharma sir will come.
He has not come, no problem. See point number 2. Huh? Senior counsel has no relevance here.
It's another day, Lordship. Any other day, Lordship.
What any other day? Matter is over. Anyways, next week you'll get a good judge. This is the matter next week, taking into account the learned counsel for the petition has not prepared. Fix a date at the review.
I am praying for 2 weeks time to file affidavit lodge. I'm praying for 2 weeks time to file affidavit lodge. Yes, sir. Yes.
Miss so appearing on behalf of the
Health department.
health department submits that 2 weeks' time is required to file the affidavit. You are not filing.
I am not able to, because my stand is clear, Lord.
What is your stand?
But it is the last phase of the picture. Because of the direction issued by the health department.
They have to pay
Otherwise, we have already requested them to raise the,
payment. Then why are you opposing it?
It is lordship as per my instructions, lordship. First it was sent to the government. Proposal was submitted to the government on 29/6/24, lordship. After that, lordship, the government has instructed to furnish completion to satisfaction report.
Completion certificate is already there.
Then lordship, the principal GMCS has issued item-wise completion certificate.
We give you time, but
Yes.
if we are to allow his petition, we impose interest upon you.
I'll file my affidavit.
We'll impose interest upon you. It is taken note of that the work in question was completed
16/9/2021.
on (18/9/2021). 2021.
No, my lord, date of completion on 16/9/2021. Page 42.
On 16, the work in question was completed on 16/9/2021 and the completion certificate was issued on 18/9/2021. The petitioner have represented the respondent authorities for the release of the your decision is against the some problem with the some okay, Anagale. The work in question has sought for time. It is taken note of that the work in question was completed on 16/9/2021. And the defect liability period of 1 year was over on 16/9/2022. The respondent authorities have not refunded the security deposit. And only in the year 2024, steps were being taken for refund of the security deposit of rupees 7,34,007 after deducting rupees 5 lakhs.
Yes.
It is under such circumstances the petitioner has approached this court. This court had issued notice as far back as on 3/9/2025. Until date, even after a period of 5 months, for 6 months being over, no affidavit has been filed. Under such circumstances, this court fixes this matter again on the 8th of April 2026. A final opportunity is granted to the respondents to deposit to file the affidavits on or before 2nd of April 2026. It is made clear that if it is made clear the pendency of the instant writ petition shall not bar the respondent authorities to reconsider the deduction of rupees 5 lakhs against the damage of the floor of the ground, damage of the ground of the floor, or damage of the floor for the work executed, which happened after 1 year from the defect liability period. Right.
The Gram Panchayat election has been challenged. Gram Panchayat, your lordship judgment is there. So May 25, the election was held.
We have to file reply, my lord. The respondent number 5 file
No,
affidavit.
we have
and
just
file
stated it
reply.
is covered by judgment passed by your lordship.
You got the judgment?
Yes.
So we are fixing it on 13th. So I'm just putting all the, putting it, everything in one basket. So that I pass one order, all the people can go together and go to the division.
My lord, in fact, item number 34,
There is
45 and 46 also same.
There is a Supreme Court judgment also in the same line, only they have added Article 243O.
I put 3 first. My main judgment is on that.
Yes. Yes, your lordship judgment is a Supreme Court judgment is also there.
And my judgments categorically
Yes,
refers
yes,
to
it says.
243O.
Yes. My lord, item 29, 34, 45 and 46, same.
All are 13.
13. Hello.
Mr. Dubey, I put your name in that order.
May I please, your lordship? Lordship, the respondent number 4 have filed their affidavit.
Page 24, my lord, paragraph 6. Page 24, paragraph 6.
Page
24, lordship.
24. Paragraph 6%. So, lordship, 12 lakhs 83,217. That was sent to the lordship authority for sanction.
No, have you made the verification?
After verification, it was sent to the authority.
Where
Lordship.
is that? Where is that line?
It is not, otherwise, lordship, it says that, lordship, they have submitted the bill and accordingly sent to the authority, lordship.
Where?
Paragraph 6 itself, lordship, all the higher search bills of the petitioners have already been taken up to the higher authority for according necessary sanction, lordship, to release the admissible amount.
So, hey, police case, dispose of paragraph 6 to put.
6 months, lordship.
And annexure A.
Lordship. Obliged, lordship.
Much of
And the details, paragraph 6, it is also seen from annexure A to the state affidavit in opposition that the amount have been duly verified, that the petitioner is entitled, the senior superintendent or superintendent?
It's a senior superintendent.
Senior supervisor.
The senior superintendent of police, who is the respondent number
4.
4, have duly verified that the petitioner is entitled to the SOMs, taking into account the above 6 months.
Much of
Obliged.
The police sorry to them.
Right, your lordship, my lord, I have filed affidavit today, my lord. I have served copy to the petitioner council also.
My lord, otherwise the amount is admitted, but from the affidavit, it feels that, my lord, the finance department has to be made party, my lord. Because because the authorities had several times forwarded the proposal, my lord, for payment. But because of the finance department, my lord, they have not been paid, my lord. Amount is admitted and several times the official respondents at annexure 11. Then, my lord.
No, how is the
Annexure 9.
finance department to be made party? I don't understand the logic behind it. If you make the finance department a party, everywhere you have to make a finance department a party.
Yes, my lord.
Even in the case of seniority also, you have to make a finance department a party. Because the seniority, once it is being given effect to, a case of notional seniority being given, there also you have to make a finance department a party, because the finance department will have to clear the bills later on.
Yes,
If you are giving a notional, but you don't require, it is a contract between you and him.
Yes, my lord.
Why is the finance department? And if the finance department comes in the way, therefore you can very well come up and say that the finance department has come in the way and not making the payment. That is their lookout. But it is when they are having a contract with you that we are going to pay you this amount, provided you do this work. You do the work, they are responsible. If they don't get the
my
finance,
lord.
then that is
And we have done the work that is admitted.
no finance.
And that is
Why-
admitted. That way your lordship may then, because the other.
We do one thing. Let her put that submission on her mouth. The finance department has to be made a party, and I reject it here. Then in the contempt, there is no necessary.
Yes, my lord.
Lordship, I'm not making that. I'm not. Lordship may dispose of the matter, but the affidavit is not on record today.
But,
Not only.
but that is admitted.
But the amount is.
Today, I have already surpassed my quota of disposal. Miss M. Deborah, appearing on behalf of the Standing Council of the Cooperation Department, submits that an affidavit has already been filed. So taking into account that the said affidavit is not on record, leaves the matter on next week,
Yes, my lord.
18th of March, along with the said affidavit.
Yes, my lord.
Lordship.
Oblige.
What are these? What do you want? Why are there certain orders I have passed earlier?
That order they have been.
Lordship, because this pertains to settlement of Mahal, your lordship, and your lordship had passed an order wherein e-tender process was not followed. Subsequently, an EC meeting was held in BDC, and thereafter the settlement of Mahals ought to have been
Okay,
procured.
let it come up next week.
Right.
It is seen that the affidavits as well as the affidavit as well as the affidavit in reply has been filed in the present proceedings. This matter again on 23/2026.
My lord, there is another matter, my lord, that was left, my lord, that was not posted today, my lord. The similar matter, my lord, another petition is there, my lord. Similar.
Along with?
That may be also listed along with this, my lord.
Along with?
Along with WBC number 6865.
Only
Up to
2025.
Right.
Get up. Yes.
I have received instruction, Lordship, in this matter. I want to file a PDP, Lordship. Kindly grant 3 weeks time, Lordship.
Why is this bench termination? Why is it before me?
Bench 3 matter. Notice was, when notice issued, this matter is.
You want to file reply?
Yes, Lordship.
Ms. Esboro appearing on behalf of the respondent submits that 3 weeks' time may be granted for filing the reply. It's a dismissal, na?
Yes, Lordship.
Place this matter again on 4th of May 2026. In the meantime, the reply be filed on or before 22nd of April 2026. Petitioner given liberty to file the reply. There against, it's advised.
Bye.
But we should dismiss his petition.
Lordship, please, your lordship.
Let's dismiss your petition. What do you say? If you come within the ambit of 10,
1A
1C.
and 1C, my lord. Sir, my lord, we are on retail licenses, my lord. We are not wholesale warehouses.
10, 1C.
10 1C, capital C, my lord.
There's no other C.
Yes, my lord. Apologies. My lord, that is in case of wholesale warehouse who import goods from outside the state.
No.
May I take your lordship of the section?
I will know. 10, 1C.
My lord, it's at page 87. Notwithstanding, has lordship got it? Notwithstanding anything contained in this act, in case of portable liquor mentioned in the fourth schedule, except country spirit, if the first sale of such item is made by an importer oblique wholesale warehouse licensee inside the state, he shall be liable to pay tax on sale of such items. Such importer wholesale warehouse licensee shall, before importing a consignment of liquor inside the state, deposit an amount in advance equivalent to the amount of tax on the estimated sale price of such liquor. In the
So
case
you
of
can purchase it from the wholesaler also.
my lord,
10, 1B
yes,
is a case where if it is purchased by the wholesaler
from the manufacturer,
from the
distillery,
manufacturer.
that is the limited dimming fiction, my lord, which is given in 1B. That wholesale warehouse says when they, the first point of sale, my lord, fourth schedule, first point of sale, the limited dimming fiction is here. That wholesale warehouse will discharge a liability of VAT in context to this sale at the point of purchase from the manufacturer or bonded warehouse. 10(1)(c) is in case where a company wholesale warehouse or a wholesale warehouse within the state imports goods in course of interstate.
That is 1D. 1D is importing.
My lord, 1C.
1C is where importing.
1C is the importer oblique wholesale warehouse. My lord, if you see the second,
Notwithstanding anything contained in Iman except country liquor, if the first sale of such items is made by an importer,
importer oblique
wholesale warehouse inside the state, he shall be liable to pay tax on the sale of such items. Such importer, wholesaler, wholesale licensee, oblique, such importer, oblique, wholesale licensee shall, before importing a consignment of liquor inside the state, deposit an amount to the advance equivalent to so and so. The importer oblique wholesale licensee shall, however, be eligible to take credit of the advance amount paid during the month against the tax liability as well, notwithstanding contained in so and so, who purchases any item from a manufacturing bottling so and so and is liable to pay tax on his purchase or on the import of the wholesale area, who is liable to pay tax on sales under this section as the case may be, may the option on the area paid so and so. So now you say that you are not required to be registered.
My lord, section 21, my lord.
Why do you say you
My lord, if there is a liability to pay tax, then I'm definitely liable for registration. In this case, there is no charge.
How do you collect tax?
I'm not collecting tax, neither I'm paying tax, my lord.
No. How are you collecting tax?
I'm not collecting tax.
So how are you selling it?
It's as good as an exempt sale, tax-free goods, my lord.
No, no. How are you selling it to him, to a customer? Is there no tax?
No tax, my lord.
You don't
As
charge
per-
tax.
We should not, by the dictum of the act and the provision of the act, we are barred from charging any tax, as there is no provision to charge tax.
So you don't, so in your bottles, there is no MRP.
There is MRP, my lord, and as per the Excise Act, we are following that MRP is inclusive of all taxes.
No, MRP is not inclusive of all
My
taxes.
lord, the excise manual states that, my lord. I will
What does
take
it
you
say?
Assam excise rules definition, my lord. I'll
MRP has to, but this, if we see section 10(1)(a)
10(1)(a), my lord.
of the VAT Act,
Hmm.
you have to pay on the MRP the tax, because this is in the
My
first.
lord, that is in case if I purchase the goods from a bonded warehouse, and lordship himself has opined in the case of Abhijit International, there is a clear distinction between after the restructuring of 2016. Bonded warehouse are the premises which are situated inside a manufactory, and anything outside the manufactory or the premises are to be considered as wholesale warehouse by definition provided in the Assam excise rules. So it is a clear distinction. Now, wholesale warehouse, the duty is paid at first point, the ad valorem duty as well as the VAT. As lordship has gone through 1A, 1B and 1C, lordship is clearly saying that the duty, the burden, the incidence is on the wholesale warehouse. Subsequent sales, there is no charging provision, my lord. And we have not been collecting since 2016. We have not been paying. We are selling it on the MRP basis. And we are not charging any and collecting any tax from the customers. Since 2016 till today, the VAT department has never questioned. The excise department is renewing our licenses. Only this time, from June 24 till 25, they have issued certain notices asking us to get registered. They have taken a satisfaction that we are liable to pay tax. And on the basis, on the premises that we are purchasing it from bonded warehouse. Whereas we are not purchasing. The wholesale warehouse do not charge us tax, my lord. Because it
You are
is
the
all,
retailers.
we are retailers, my lord. So they issue us these notices, and subsequently they also, at page 94, my lord, there is a circular. If your lordship will see that. This is issued by the Commissioner and Secretary to the Government of Assam Finance Taxation Department to all the district commissioner. And so paragraph 1. It has been observed that a number of on-shop licenses have not yet complied with the provisions of page 94, my lord, annexure E.
Yes. We got to stay on this.
Yes, my lord. On the last occasion, your lordship were pleased to grant an interim protection. But even then, my lord, only the impugned VAT notices at page 84 were stayed. And your lordship had taken this belief that since the parent actions, which entails the tax liability and VAT registration, are stayed, the excise authorities will not demand for certificate of registration for renewal of licenses.
That has been given.
However, my lord, even after passing of the interim protection on 22nd January, yet the respondents are resorting to ways and means and compelling us to take VAT registration. To demonstrate that, my lord, if I may provide certain notices, it will be going. No, more of my PS. Access. The interim protection was granted on 22nd January. Letter issued from District Commissioner Vishwanath, the collector. With reference to the subject cited above, all the MFL loan shop under Vishwanath district are hereby directed to register under the EVAT Act 2003.
Does the VAT Act define what's a tax-free goods?
Yes, my lord.
Where?
It's in
Tax-free goods will
definition.
be exempted.
Those goods which are defined in first schedule of the act.
Huh?
First schedule of the act, my lord.
That is exempted.
That is nil rated, my lord.
No,
There
that
is-
is to be exempted.
Yes, exempted.
Exempted, would it mean? First schedule are exempted goods.
My lord, the specific definition is not given in the this act, but there is a exempt. What is exempt sale is defined in the rules. If I may take your lordship there. If lordship come at page page 65, my lord, you have a book. I don't know if this it's the same edition.
Section?
250.
Rules.
Definition part, my lord, section 2, subsection 50.
Dealer.
Tax-free goods, my lord. Page number may change, my lord. It's 65 in my book.
Tax-free, means goods against which the rate of sales tax is shown to be nil in the first schedule.
Yes.
So therefore, the exemption not to register is only in respect to tax-free goods.
My lord. Now, may I take your, my lord, to rule 9 in the rules of the Assam Valley?
No, the rule 9, if you see section 11, which is the taxable turnover.
Yes, my lord, for.
And rule 9 will be in terms with 11(1)(d).
That is there, my lord. This is the confusion, my lord. We are also facing. Now, what happens to the goods which we are dealing, my lord?
Determination of taxable turnover, amount charged separately in so and so. Yes, where, in which case?
There has to be a taxable quantum and taxable turnover, my lord. And there
Now,
is
my
no-
question is,
my lord.
my question is, registration, just for example, in income tax, a person may not be liable to pay income tax. But he is required to submit his return.
That is correct, my lord.
Here, the exemption is only given to those where it's a tax-free goods.
That aspect may be decided by your lordship. We are here before your lordship for that only, my lord.
Because here the legislature have used the word
My
tax-free
lord,
goods,
if
but
that
have
be-
not said
if-
where a person is not liable, because otherwise you are engaged in the business of sale. You are selling it. There's a transaction of sale by
And my-
you to the consumers.
My lord, then again, this commodity is falling in fourth schedule. Had it been in different schedule, all the schedules are redundant after.
If you are in the first schedule, no problem. But if you are in the second schedule, you have to,
We had to be, my lord.
had to be. Now you are in the fourth schedule,
We are in
meaning whereby it is the first point of sale.
first point of sale, my lord, is
Understood. The first point of sale will be the wholesale warehouses. There's no quarrel.
my lord.
First point of sale happens there.
Yes, my lord.
But it is not an exempted.
It is not exempted. That
It is not exempted. So under such circumstances, the only thing it is mentioned is provided it is not required only in the case of tax free. So how, and taking into account the definition of 250 of tax free,
no,
which is there
My-
in only schedule 1.
that word coined tax free may not be proper, my lord, but these are goods which are left untaxed, my lord. As there is no
These are
charge,
not untaxed. This tax has already been paid.
tax has already been paid.
It is not untaxed. But for the purpose of taking into account that these are VAT, value added tax. So therefore, there might be a question out there that whether you have no problem out there for just to submit your return. What is your problem with the return being submitted? Or filing of your register or getting your registered? But that is not exempted. 21 does not say. So therefore, this court have to hold it that you are not required means you have to say that the proviso will also include which are tax already suffered goods. Because there cannot be, this is only one point of sale. Tax is charged at the first point of sale. If it is the first point of sale, then it cannot be said to be exempted.
That is correct, my lord, in that aspect. But if I may submit, my lord, if
We are having another matter on the other issue, and in fact, your thing may also make the matter better. I have fixed it when to item number.
the matter, my lord, took in the morning,
What is the item number?
it was 6-7, my lord. 6 and 7, if I remember correctly.
Okay, let us have that on. When did we fix it? 23rd. Let's have it on 23rd.
My lord, in the meantime, I make a small prayer, my lord. As per rule 129, the excise authorities are going to sanction the licenses for the coming financial year. They will take a call on that. And there's, as I have produced, they are insisting on VAT registration. Unless and until this aspect is decided by your lordship, there is no harm. If we are required to take registration, we will take registration, my lords. But at this juncture, when the license are being issued for the next financial year,
Mr. Counsel,
my lord,
till 23rd of April, nothing is going to happen. Nothing is going to happen. No license will be renewed. No license, nothing is going to happen. Taking into account, I think 2-3 days time, model code of conduct is coming. They are not going to do anything. So therefore, don't worry. We're having it on 23rd. We'll consider then. If you want to file it, you will file an IE.
my lord.
List this matter again on 23rd of April 2020. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. B. Chaudhary appears on behalf of the Finance and Taxation Department of the Government of Assam. Mr. D. Gogoi appears on behalf of the Excise Department of the Government of Assam. First of the list this matter, taking into account that a similar issue is also pending in another petition which have been heard by this court in detail, that is in WPC number OP Bhattir matter to the auction. Huh? Book the hub. In in WPC number 3025/2020, which is fixed on 23rd of April 2026, lists this matter along with the said writ petition on 23rd of April 2026. The interim order passed earlier shall continue till then. There's an interim order, na?
My lord.
We'll have it on that day. But only problem that is it. From registration, I think you need to register. It's a different thing. But I think you need to register.
My lord. Obliged.
36, 37.
In this matter, respondents are permitted to file affidavit, Lordship.
Respondents have not filed affidavit, no, my lord. Okay, the respondents having not filed the affidavit list this matter again on 25th of March 2026. A final opportunity is given to the respondents to bring on record their stand by filing the affidavits.
Obliged, Lordship.
Appearing on behalf of respondent 6 to 11.
No, respondent, official respondent. Pharmacy council have not filed.
I'm appearing.
Oh,
But
you
can it
file
be
it by
30th,
25th.
30th, man.
30th. Why you want it? I'm not there these days. That is why I'm fixing that matter and you want this matter to be in. 27th. Affidavit be filed or not before 25th of March. What is this? Bank account. How much amount?
Disputed amount receipts or 6 receipts.
Huh?
5 receipts or 6 receipts of complaint by the cyber police.
How much?
And amount is very 2000, 1000. Your Lordship starts from page number 11.
Amount?
Page number 11.
Which one?
Annexer 1, Your Lordship.
And page
That
number,
is
how much?
1000 rupees.
1000.
And then Your Lordship in page
2000.
number 12,
3000, 5000.
it is 2000 rupees.
Huh?
Then Your Lordship page number 13,
Various amounts.
it is 4000 rupees.
Total how much?
Yes, Your Lordship, I am coming. And total Lordship.
How much is the total?
47,700 Lordship.
Huh? Lot.
12 numbers of complaint.
So you do one thing, find out how much it is, put it on affidavit, a short affidavit, or give us the instruction on that.
Yes, sir.
How much it is. Then we put a lien on that amount and use it, allow him to use it. This is the law.
I think Your Lordship, their submissions maybe, their submission is sufficient, 47,700 Lordship.
Huh?
47,700 Lordship.
Is the amount
12 numbers
is
of
the amount
complaint.
disputed?
Yes. Sir. That may be keep on hold and remaining.
Where you mention, yeah, that the total here is here has an approximately 3 lakhs Iman as on Iman in his current, but on so and so and so. Amount of Iman has been earned through the number of Iman. Okay. It will lekhi play more at a judgment at a sin one. It will lien D. It will put it. We dispose it of.
Yes, sir.
M. Sharma for respond number 3 and so and so. We put it at a lien on 47,700 and that would be not released till further instructions are not received from the respondent number 4. So you keep a lien on this till instructions are not received from the respondent number 4. However, you allow him to run and keep 47,000 insurance.
Yes.
Ito hitna eta order issue. Sibani ko dilo.
Obliged.
Give your names, huh, councils.
My lord. Here the disputed amount is 2000, my lord.
Huh?
Disputed amount is 2000, my lord. They have
2000?
2000 only. That is, my lord, affidavit in opposition, page 38, lordship.
Disputed amount is how much?
Page 38 is the complaint they have furnished, my lord. And the down below, disputed amount rupees 2,000 put on hold along with other.
Wait. Page?
Page 38, lordship, the affidavit in opposition.
Ah,
Lordship would see in the down below, in the middle column, my lord,
where?
page 38. And it's a 1,
2,000?
2,000.
Lordship, I appear on behalf of the Mr. H. Burago.
Whatever may be. How much is the disputed amount?
2,000.
2,000 or 4,000?
2,000, Lordship.
Why don't you write? Why you are writing a long petition unnecessarily? Why you are writing in the current, and therefore I further submit as on date the ledger balance reflected in the said current account stands at rupees 25 lakhs. This is your account, 25 lakhs.
Lordship.
Huh?
25 lakhs is the, my lord, total amount, balance, my lord, total balance. But 2,000 is the disputed amount, my lord.
No, they say the amount received credit from multiple sources located across different persons, mostly involving small value transactions which cumulatively aggregated to a substantial amount of rupees 40 lakhs 75,000 in a single day. Pattern is characteristic of a mule account activity and raised serious suspicion.
That is suspicion, my lord. And the complaint that has been received by the bank, my lord, page 38, annex of 1.
Fraudulent transaction, fake Instagram ID fraud.
In the down below, lordship will find transaction amount 2,000, disputed amount rupees 2,000, put on hold along with other holds and stock. And in my bank statement also, lordship will find the hold amount is 2,000 only. That is, my lord, page 24 of my writ petition. It is the bank statement of my account. Lordship will see hold value is 2,000.
Where?
Page 30, page 24, lordship.
Whole value is 2,000.
2,000. And account balance is 25 lakhs 72,000. So and so.
Okay.
So.
Who is your senior?
It's Burago High, Lordship.
Where is he?
Lordship, he is out of station because his father has been admitted to the hospital, Lordship.
You do one thing. Take your instruction. We'll have it tomorrow at 2 p.m. Get his instruction and ask him to put it on the, yeah. Huh? Because you see, I understand his problem, but on the other hand, he is also having a problem. We need to dispose of this matter. Otherwise, we can keep on hold this 2,000 rupees or so and so. Or ask State Bank to engage some other advocate. List the matter. We'll have it on 13th at 2 p.m. Get in the meantime, taking into account that Mr. H. Buraguai is not present, list the matter on 13/3/2026 at 2 p.m. Liberty, Mr. So-and-so appearing on behalf of the petitioner expresses great urgency taking into account that his bank account has been freezed.
Obliged.
Well, in this case, I have received the instructions today, my lord. Kindly give me some time, my lord. I will file the affidavit in the matter. Otherwise, my lordship has directed. Well, the
this one, yes.
Water facility that has been provided, my lord, they are availing that. And my lord, the one medical facilities are also provided, and my lord, one LP school is there, my lord.
List the matter on 13/3/2026 at the top of the list.
Lordship, nothing of your lordship directions have been complied till date, your lordship.
Mr. Counsel will have it on 13/3/2000 at the top of the list.
Oblige, your lordship.
Bring your records. What is this?
Lordship, it's a matter where we have been issued eviction notices, Lordship. There was certain eviction notices have been issued to us, Lordship. Those have been stayed by this honorable court. We are allotment holders, Lordship. Our allotments were cancelled without issuing notice.
You got to stay?
Yes, yes,
Okay. They file affidavit in opposition.
Lordship. Pleadings are completed. Lord.
Hello, we have it on next week or day after.
Can we dispose of by not saying any day today, of course, when it's Whether pertains to my installation of a solar.
Oh, that matter. Hubri. There was another near Tezpur or something. Is this the matter I dealt with? No. This is another one.
Is a different matter. This is a different matter.
Okay, that is nearby Tezpur, na?
That was a project nearby Tezpur. It was also, that was also a solar project. No?
Okay.
This is a solar project in Dhubri district.
Hello. When can we have it?
On 17th. No?
Eh?
17th.
Then I'm no problem. I am not taking up anyway. I am not here. Okay, 17, na? 17, but would it be proper on the part to fix it on 17? It's a Tuesday, na?
It's a Tuesday. 17th.
Because I am not holding the bench, so it will be somebody else. List the matter again on 18th?
18th.
18th. Interim order passed earlier shall continue till then.
Much obliged.
If this matter is top of the list.
I can't because I am not sitting on that day.
Mate, this is your lordship. Your lordship, by last order dated 25/2/2026, the respondents were directed to file affidavit.
Affidavit file.
Not filed.
Affidavit not filed today itself, Lordship. I have received the instruction whereby, Lordship, though they have stated that it was cancelled, it was not been cancelled. The sale permission, it was kept in abeyance as because there is a discrepancy was found. Accordingly, on 5th of March, a letter is written to the Deputy Director of Survey for a joint inspection. So that after the joint inspection, Lordship, most probably this matter can be solved and for the Director of Survey.
Mr. H. Sharma, the learned counsel appearing on behalf of the petitioner respondent submits that he has received the instruction but could not file the affidavit due to paucity of time. He however submits that there is no cancellation, that the application for seeking sale permission has not been cancelled. And in fact, a report has been sought from the Joint Director of
Survey.
And on the basis and on 5/3/2026, and thereupon, upon receipt of the said report, due action will be taken.
Lordship.
Taking into account the above, list this matter again on 30/3/2026 for an update.
Lordship, one addition. It is not the application for sale permission that was cancelled, but the sale permission itself was cancelled after it being issued by the office of the district.
Because of that discrepancy, most probably. But my instruction is that it was kept in abeyance.
But the NGDRS shows one
Submits that
affidavit
the
is
sale
cancelled.
permission was not cancelled, but it was kept in abeyance. We'll see to it, don't worry. On 30th for update.
It was
In the
our
meantime, the affidavit.
This sentence is there. it was
Mr. H.
stated-
Sharma,
Lordship.
I am fixing it on 30, taking into account that I am coming on that date and taking up this bench. So therefore.
Lordship is fixing
that
on
is the reason.
30. Lordship.
Deeply obliged.
What is this?
We had filed one affidavit as regards service on.
Service is complete. Service complete.
We were directed to take steps. We took steps. We also went to the respondent number.
Why the
5.
matter of 2008 is pending?
But what has happened in between, this was dismissed for default. Thereafter, we filed restoration petition. In between, the petitioner expired, respondent number 1 expired, respondent number 5 expired.
Service complete.
But yes, we have filed an affidavit that they have refused to take service.
Fantastic. Taking into account the service the affidavit filed by the petitioner regarding justice service, this court deems that the service upon the Respondent number?
5ABC.
5ABC is complete.
PNE.
Full stop. List this matter, taking into account that the instant writ petition is a very old pending matter. List this matter for final disposal on 2nd of April 2026. At the top of the list.
Well, Millie Lordship, second, I have a fixed matter. My lord, I'll just seek for some accommodation. My lord,
Don't.
second. No, I'll do the argument on that day. Only, my lord, some matter has been fixed because NCLT. I'll take half an hour there.
Either 2nd of April, there are a lot of time. Either engage some other council or appear anywhere. 2nd of the April, top of the list, don't appear, dismiss for default and not to be restored in future with that order.
Fixed matter, that's why I'm making that.
I am also fixing it. Don't make this type of submission. Okay, the amended cause title having been submitted, I list this matter for admission in the month of on 6th of April 2026.
Deeply obliged.
But Palma is really late for orders. You have a late for orders. Service complete? Service complete?
My lord, I'm for respondent 1 and 2.
Service complete or not? Respondent number 3, anybody appearing?
I appear for 4.
What is this? What is the matter about? Let's put it for a year. Who is respondent number 3?
My lord, I am the company executing. I'm respondent number 1 and 2, my lord.
Why do you need a respondent number 3?
There is the power grid you can answer. The power grid council is online. If the power grid will be the main respondent, they are online.
My lord, I am the main. My lord, I'm the main respondent 1 and 2.
Service being complete is the matter for admission on 23rd of March 2026.
Fully obliged, my lord.
Meet please, Lordship. The service
Service
is
complete.
complete, but respondent number 2 has not yet filed their affidavit. That's the main affidavit actually.
Not okay. Service being complete is the matter for admission.
Obliged.
Any date may be fixed.
On 25th of March 2026.
Obliged. Interim orders may be continued.
Interim orders passed earlier shall continue till the next date. Yes, why? What has happened?
Sir, I have given the detailed reply why I could not present in that court.
Why you have not been present for a long time?
On 2 occasions, it was due to death of my mother on 18 December. Until February, I was in my hometown in Rajasthan.
Your mother died when?
On 5th of December. 5th
6th of
December, 5th,
6th of December 2012.
25. 25, your lords.
18/12/25, 5/12/25 mother died.
5/12/2025.
Yes, yes.
So therefore, 18/12 is okay. But what about 13/8?
Because I was there because there are certain family responsibilities for
Then
me.
what about 2/2?
I am telling you about the February date, your lordship, because there was certain family responsibilities in my hometown.
Okay,
That's why I
heard
was
Mr.
there.
So-and-so, the learned counsel, the petitioner in person. There is an application filed for recalling the order dated 2/2/2026, whereby WPC number, the accompanying writ petition being WPC number 203/2025 was dismissed for non-prosecution. This court had duly perused the application so filed and is of the opinion that the grounds so as mentioned therein appears to be good grounds for restoration of the writ petition. Accordingly, the instant application stands allowed, thereby recalling the order dated so and so 2026. I stands disposed. Recalling the order dated so and so and WPC number 203/2024. 25 is brought to the records of this court. Is brought to the records of so and so is brought to the file of this court. It would be allowed. List the matter for admission on
Next week, your lordship.
23/2026.
Thanks.
Here's what is this review?
Review of order dated lordship 21/1/2025. Similar review lordship has fixed on 12th of this month, tomorrow lordship.
Okay, list the matter tomorrow. $50. Yes, Mr. K. Mojumdar.
Lordship, the service complete, Lordship, my landed friend has appeared, but I filed an IA, Lordship, for continuation of the interim order, Lordship.
What?
And for continuation of the interim order, earlier interim stay order, Lordship. And as well as for further prayer for vacation of the stay order, the learned court below regarding attachment of bank account, Lordship. Because it is a Gau Panchayat matter, Lordship.
What matter is this?
It is a relating to, Lordship, the tax party award passed by the permanent Lok Adalat Silchar Kachar, Lordship, against which a decree was on execution, and on the execution of the degree,
So what
Lordship.
do you want now?
Now I pray, Lordship.
Why the IA has come?
I filed an IA for continuation of the interim order as well as for vacation of the attachment order, Lordship, of
Who
the
has
bank.
filed? Who has filed the vacation?
This is the petitioner, Lordship, present petitioner.
Huh.
Filed a petition because the learned court below attached the bank account, Lordship, of the for which the functioning of the bank account banks of the Gau Panchayat, Lordship, is
But the interim order was extended 6/2/2026.
Lordship.
Not
But-
extended, not extended.
Extended.
My lord,
Interim order passed in so and so will continue till the next date of listing. The
Lordship,
matter has
today.
come up today.
Today, Lordship.
Then
So I pray, Lordship, the interim order may kindly continue. And also
we
further.
have objection, my lord, we'll file an objection petition. My lord, after.
what is there to file? Have you filed your reply to the affidavit?
No, no.
Then
My
why
lord,
are not
that-
unnecessary?
my lord, date before today, my lord, yesterday, my lord. We filed the ukalat now.
Okay.
Out any.
We do one thing.
Matter may come up in the admission column, and that matter will be disposed of.
Now we dispose of the IA today itself, saying that interim order shall continue till the next date in the main writ petition. And this is closed. Matter over. Because unnecessarily, because of this, the matter will always come in the down.
Loss.
This IA, because of the IA,
My lord,
it must be the good handiwork of Mr. K. Mujumdar to get the matter at 5:15.
But
Fasting.
my friend is making wrong submission.
Oh.
It is a second round of litigation, my lord. It is
Yes,
not- How it can be
Why,
acquired order?
why
Okay.
my learned
okay.
friend is submitting,
Okay,
Lordship?
then we do one thing.
Lordship, please.
We, with the both the consensus of both the parties,
Lordship.
we extend the interim order passed in 9/1/2026 till the next date
My lord,
and close this IA
my lord,
and then put it for admission.
my lord.
Heard Mr. K. Mujumdar, the learned counsel appearing on behalf of the petitioner, and Mr. A.R. Sigdar, the learned counsel who appears on behalf of the private respondents. Private respondent
My lord.
All are private respondents.
appears on behalf of all the respondents. Full stop. Mr. A.R. Sigdar, the learned counsel appearing on behalf of the respondent submits that he would like to file an affidavit. Affidavit.
Yes.
Full stop. And in that regard, submits that 2 weeks' time may be granted in that regard. List this matter on 1st of April 2026. So both the parties agreed that the interim order, this court extends the interim order passed on 9/1/2026 in the writ petition till the next date. The affidavit be filed on or before 27th. আগত লিখি তাৰপিছত this court extends the interim order passed on 9/1/2026 till the next date. এইখন দিলে এইখনত লিখিব the in view of the order passed in the writ petition, nothing remains in the instant application. Application stands closed.
Actually, Lordship, entire bank accounts of the Gau Panchayat
Okay,
were
no
restored, for
problem.
which I filed this. People are seated, seated by, not by us.
During the pendency of the repetition, the petitioner has expired. So this
The
I has been-
substitution.
Yes, your lordship.
Who died?
The petitioner itself died.
Huh?
So the legal heirs has been brought in.
Who died?
The petitioner, your lordship.
Sole petitioner.
Yes, sole petitioner. 13/1/21 he died.
Any objection?
It was in time now.
There is an application filed seeking substitution of the sole petitioner of the accompanying writ petition, taking into account that the sole petitioner expired on 13/1/2021. Full stop. The sole petitioner is survived by
Page 4.
the persons whose name who are the applicants in the instant application. Full stop. The counsel appearing on behalf of the respondents submits no objection. Taking into account the above, this court substitutes the petitioner with petitioner of the accompanying writ petition by the applicants of the instant application. Full stop. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court. No, file a fresh memo of parties before the registry of this court. And the registry shall, on the basis of the present order as well as the memo of parties, make necessary correction in the cause title of the accompanying writ petition and update the same in the CIS. I stands disposed. The main khonot dibo. Mr. This matter again on admission.
Yes, sir. Also, pleading
This is the matter for admission on 27th of March 2026. Complied?
Yes,
Complied.
payment has been made, your lords.
Payment?
Payment has been made, your lords.
It has been submitted by the Mr. K. Gogoi, the learned additional senior government advocate, that the petitioner have already received the amount of rupees 55 lakhs.
No, Lordship.
84,000.
Lordship, 49 lakhs.
Wait, please. 040. And after the necessary deduction of tax, the amount paid to the petitioner is rupees 49 lakhs 36,729. In that regard, he has placed before this court an order dated 19/1/2026, which is kept on record and marked with the letter X. Taking into account the above, Mr. So-and-so, who appears on behalf of the petitioner, also submits that the petitioner have duly received the amount after necessary deduction of tax. Accordingly, the judgment and order passed by this court dated 5/8/2024 in WPC number 2814/2024 is been complied with. The contempt proceedings accordingly stands dropped. Mr. Arbupazhi appears for whom? For one, you for?
Two, Lordship. Two.
Service on notice has been completed. Service being complete leaves the matter for admission on.
Well, I'm just for respondent one, madam.
Okay, on 25th March 2026.
one small accommodation, item number 47, Lordship is fifth on 25th of this month for admission. But can it be on 27th or 30th? I have some
20?
difficulty. Either 27th or 30th, whichever is convenient to your
Possible on 30, Lordship. 30 March, if possible.
27.
47. 47.
When do you want it?
30th, if it's
30 March.
30.
obliged.